Dampness and other assets. Only
You don't want the closure of seepage? Yes, sir. The direction is 6 months should be closed. All these problems in 2018. We are 2022. They were all for 4 years they were sleeping. When you pass the order, now they seem to have got up from the sleeping. And they have said, why you people are objecting? You don't want control the dampness and other essential infrastructure. ಅಲ್ಲರಿ ಇಲ್ಲಿ ಕೋರ್ಟಲ್ ಡೈರೆಕ್ಷನ್ ಆಗಿದೆ ಅವ್ರು ಮಾಡ್ಬೇಕು ಅಂತ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಅಪ್ರೂಟ್ ಆಗ್ತಾರ ಅವರು ಪಾಸ್ ಅವ್ರು ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ಇದನ್ನ ನೀವು ಮೊದಲೇ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ ಅವ್ರಿಗೆ ಇಷ್ಟಿಟ್ಟು ದಪ್ಪ ಬುಕ್ಗಳಾಗಿ ಕೊಟ್ರೆ ಏನಕ್ಕೆ ಬೇಕು ಜಸ್ಟ್ ಫೈಲ್ ಅಫಿಡವಿಟ್ ಅಂಡ್ ದಿ 4 ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಷ್ಟು ದಪ್ಪ ಹಾಕ್ಬಿಟ್ರೆ ಇದನ್ನ we are not concerned steps. What is the implementation? We are not concerned, Bimaya. Steps, you know how you people work. 4 ವರ್ಷ ನಿದ್ದೆ ಮಾಡಿದ್ದಾರೆ ಇವಾಗ ಎದ್ದು ಬಂದಿದ್ದಾರೆ ಅವರು ಕಂಟೆಂಪ್ಟ್ ಇನ್ಸರ್ಟ್ ಆಗುತ್ತೆ ಅಂದ ತಕ್ಷಣ Sir, mere correspondence is not amount to compliance. That is nothing but a violation. 6 months ಮಾಡಬೇಕು ಅಂತ 2018 order. If you could not done anything, you have asked before Learned Single for extension. That is not done. As it is contempt as on today. Even now you are not done. Or adda bandru anta idu vasa theory. Ivaga avaru bartare ನಾವು ಯಾವುದು ಅಡ್ಡ ಮಾಡಿಲ್ಲ ಅಂತ. Then will come the charge. ಇವಾಗ ಅಲ್ಲ ನೀವು ಹೋಗಿರೋದು ಇವಾಗ only when the last time this court passed the order ಆಮೇಲೆ ಹೋಗಿರೋದು we are nothing to Mr. Bhimaya, we are nothing to do with your correspondence. We want implementation within 6 months from the date of the order. You are not done. We will impose heavy cost on these people for not complying all these 4 years. Only on 28, Tahsildar Assistant visited only on 28. 28 20th ಆರ್ಡರ್ ಆಯ್ತು ನಮ್ದು 20 ಆಮೇಲೆ 8 ದಿವಸಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ ಅವರು ಇದು ರಾಜಕಾರಣ ಮಾಡಿದಾಗ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ ಯು ಫಾಲೋ ಯುವರ್ ಫಾದರ್ಸ್ ಅವರು ಎಲೆಕ್ಷನ್ ಟೈಮಲ್ಲಿ ಮಾಡ್ತಾರಲ್ಲ ಅದಕ್ಕೆ ನೀವು ಮಾಡಿದಾರೆ ಅಷ್ಟೇ ಸೇಮ್ ಈ ಪೇಜ್ 168 ಅಲ್ಲಿ any of the complaints are here? Any of the complaints are here? Page 168. ನೀವು ಸೈನ್ ಹಾಕಿದ್ದೀರಾ ಯಾರ್ದು ಅಲ್ಲ ಇದು ಪೆನ್ ಸೇಮ್ ಇದೆ ರೈಟಿಂಗು ಸೇಮ್ ಇದ್ದಂಗಿದೆ
ಗ್ರಾಮಸ್ಥರ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ವೀಕ್ಷಣೆ ನಡೆಸಿ ಸರಿಯಾದ ವರದಿಯನ್ನು ಸರ್ಕಾರಕ್ಕೆ
ಅಲ್ಲ ಯಾರು ಕಂಪ್ಲೇಂಟ್ಸ್ ಯಾರ್ದಾರಲ್ಲಿ
Whether the very complainant has signed this.
ಮಿಸ್ಟರ್ ವೆರಿಫೈ ವೆದರ್ ದಿಸ್ ಮಾಸವಳ್ಳಿ ಗ್ರಾಮ ಯು ಆರ್ ಫ್ರಮ್ ಮಾಸವಳ್ಳಿ ಬಾಮ in portions of the order passed dated 20th October 2022. Now the fourth respondent, Executive Engineer, Kaveri Niravar Nigama, Yagachi Project, Division Belur Assam District file is affidavit along with Annexure 32 stating that the Tahsildar of CCNL Beluru and Assistant Executive Engineer CCNL, Executive Engineer CCNL, Assistant Executive Engineer CNL Belur Taluk visited the Masuvalli village on 28/10/2022. The villagers were present on that day objected to carry out the construction of seepage drain to control dampness and other essential infrastructure works in Machali village, Bengaluru Taluk, and also given representation to the executive engineer. ಏನು ಮಾಡಬೇಡಿ ಅಂತ ನಾವು ಹಂಗೆ ಸಾಯ್ತೀವಿ ನೀವು ಹೋಗಿ ಅಂತ ಹೇಳಿದಾರ ಈ ಸೆಟ್ ಸಬ್ಮಿಷನ್ ದಿ ಅಫಿಡವಿಟ್ ಇಸ್ ಬೇಸ್ಡ್ ಆನ್ ರೆಕಾರ್ಡ್ ಸಿ ಸೋ ಅಂಡ್ ಸೋ 6 ಟೈಮ್ ಟು ವೆರಿಫೈ ಅಂಡ್ ಸಬ್ಮಿಟ್ ಅನ್ನೆಕ್ಚರ್ 32 ನಲ್ಲಿ ನಿಮ್ಮೂರು ಇದಾರ ಅಂತ ನೋಡ್ರಿ ಚೆಕ್ ಮಾಡಿ ತಂದ್ಕೊಡಿ. If a statement is false, Dimaya, tell your officers, we don't believe you and these people. We know get it, how to get it. Legal sources and that. We will get our legal source authority, member secretary there. He will visit the spot, we will get the details. Next week, government advocate vanishing. All right, next same. Kodi. Same akam next time. Next week. Repair ಮಾಡಿ ಚೆಕ್ ಮಾಡ್ರಿ. ನೀವು ಅಲ್ಲೇನಿದ್ದ ಮಾಡಂಗಿಲ್ಲ ಅಂದ್ರೆ you are doing against the order passed by single judge. Then we will dismiss with the contempt petition with heavy cost. You can't play with the court. Yes, that's it. Yes, Mr. Government Advocate. When? 10/1/2020. Read 20th October 2022. The order passed by this court. Am I ಹೇಳೋದು? ನೀವು ಗೊತ್ತಿಲ್ಲದೇನೆ ಏನೋ ಬಂದು ಹೇಳಂಗಿಲ್ಲ. ಓದಿ. Members of the party, they will be government advocates. Where is the accused persons? Where is the accused person? We will frame the charge. Pass off. Yes, ma'am.
Cause of action, not for time.
Last time other ಕೊಟ್ಟಿದ್ದೀವಿ. Then appears for complaint. Gita Devi M Papa 6 time. Friday, Thursday, next Friday, next week. Next week. Yes, Amar Kaur. Yes, ma. Case called out twice. Neither the accused appeared nor filed reply. Hence issue non-bail warrant to accused to judicial police. Where the yes. Okay. Yes, where is your advocate? Why last time you are not there? What do you mean by inconvenience? When you are representing the council, the party, you should make all arrangements. Inconvenience is nothing. You have been engaged with a trust by the client. How can you ditch that trust? Because of a mistake, now you have issued a non-bail warrant to our client. Police people brought. Because of your mistake, she has to brought before the court and state has to spend expenditure. 2 police officers appointed. What is this, sir? What mistake? Is not almost a misconduct? Apology harkbeko. Yes, ask her why you are not complied. The order. Please read the order. Page 21. Where is the file? Nimshamma. When you ask the other side, you have no business to interfere. ಅಮ್ಮನ ಕಡೆ ಓದ್ಲಿ ಅವ್ರು ಕೊಡಬೇಡಿ ಅವ್ರ ಫೈಲ್ ಇಲ್ಲ ಅವ್ರಿಗೆ ಯಾಕೆ ಕೊಡ್ತೀವಿ read page 30 ma the interim application so and so by the petitioner by your husband is allowed party allowed respondent ತೆಗೆದುಕೊಡಪ್ಪ page 30 ಅಲ್ಲಿ respondent is directed to hand over the minor child Shruti ಓದಮ್ಮ ಓದಕ್ ಬರುತ್ತಾ
The respondent is directed to hand over the minor child Shruti to the custody of the petitioner from 30th September 2019 to 5th October 2019 before the Deputy Director of Bangalore Mediation Center without fail.
read further.
The respondent is directed to bring the child to BMC at 11 a.m. on 30/9/2019 and the BMC Deputy Director is directed to make arrangements for handing over the child by name Shruti to the petitioner and the respondent. The petitioner is directed to hand over the custody.
That all right. That you are not done. There is no question. We are done. Next. Page 31 Odi.
If the respondent fails to hand over the custody of the child smoothly in favor of the petitioner, then the jurisdictional police are directed to give the assistance to the women police to enable the petitioner to take the immediate custody of the child in a smooth manner.
Yes. When you handed over the child to her husband in terms of the order passed by the family court on 27 September 2019.
There was a history that he misbehaved with my daughter. She started crying whenever I bring her for the visitation. She was really upset.
Madam Devakumari, if order could not be implemented, what prevented you go before the family court? Make whatever the problem. You can't ignore the court order like this.
I obey
First, get this child 230, where you are coming from? Bengaluru. Get the 230 child handover, then do whatever you want.
My lord, I will present her in front of you. Please talk to her, my lord. Now she attained the puberty also, my lord. Please. So,
That is immaterial for us. You can't ignore the court order.
introduce you in front of you.
Being a mother, can you ignore the court order?
No, my lord. I will not accept. Please call
Because of the you people, the ego between husband and wife, you want to destroy the child.
No, my lord. Please trust me.
Are you educated?
Yes, my lord.
What is your education?
I completed my MBA, my lord.
You are an employee.
Yes, sir. Yes,
You
sir.
do like this.
No, my lord. There is some miscommunication.
From 2019-22 till miscommunication.
No, my lord, because of COVID, they said everything got this.
And this contempt you filed 2019, you are 2022. COVID vanished.
COVID, I got to know in my native place.
Though COVID vanished, you people, ego COVID not vanished.
No, my lord. Definitely not my lord.
First hand over the husband, gracefully.
I will hand over to you, my lord. Please, that you have ordered, my lord. Please, my lord, you talk to the child and then decide, my lord. Please,
Madam, this order, if according to you, is wrong. You should have challenge. Once there is an order, should hand over, do whatever you want before the family court. This is the order of family court 2019. You are not challenged.
I told them to send a response with all. I already hand over all the evidence, everything to my counsel.
Madam, please understand what you are asking. The order passed by the family court 27 September 2019, directing to hand over child. Did you challenge that order? ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ ಅವ್ರು ಕೇಳಿದ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತಾಗಬೇಕಲ್ಲ ನೀವು ಹಾಕಿದ್ರೆ ಐ ಯು ಫೈಲ್ಡ್ ಅಪೀಲ್ ಅಗೇನ್ಸ್ಟ್ ದಿಸ್ ಆರ್ಡರ್ ಒಬೆ ಫಸ್ಟ್ 230 ನೀವು ಏನಾದ್ರು ತೊಂದರೆ ಇದ್ರೆ ಗೋ ಟು ದಿ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಇವತ್ತು ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿ ಇದ್ರ ಪ್ರಕಾರ ಅವ್ರು ನೋಡ್ಕೋಬೇಕು ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡಿಫಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ ಏನ್ ಬೇಕಾ ಹಾಕೊಳ್ಳಿ
He's in UK.
ನಾವು This is already over. Read the second paragraph. 30th September 19th, 5th September, over. Where is the contempt?
Plus contempt because there were orders. but
You want?
It is not one order.
No, we are not concerned. We are challenging only one order here. Don't argue everything. You are a egoistic husband. If a fair husband, you should have fairly said,
Lord, this order was she participated in the
Madam, don't argue all the things. What is the order?
order is to for custody of
That is not done.
that is not done.
When did you file this contempt?
Lord, I
20th October. After the period is over. Should have filed immediately.
filed immediately before the family court laws. I intimated her the orders of laws.
If you already, 1 minute, if you already filed before the family court, how can you maintain this?
I had a memo of non-compliance to the family court.
You should have pursued. How can you seek parallel remedy simultaneously before the contempt court? You are misusing.
Because in the family court laws, we have not sought for any action against her, but we brought it to the knowledge of the family court laws. Your order
Where is the question of file memo? Where is that memo?
is now not produced because
Why? You should put along with this petition. Interim arrangement. Matter still pending?
matter is now Lord's disposal.
When did the matter dispose of? What happened?
Lord's there was an order. Lord's
Madam, don't waste public time. We are just asking you what happened in the main matter.
Lord's in the main matter, Lord's was kept for Lord's evidence in the petition. These orders were passed and no order was obediently followed, Lord's, or no order was applied.
We are asking you what happened. Final.
Lord's, it got dismissed for not.
Then,
It got dismissed.
then you want to pursue this. Your petition is now vanished. You want again harass. And your child now attend puberty when? During the penance of these proceedings? We want to harass now. Where you are there? Where you are there?
Where are you staying? Where is the husband staying?
Presently will kill.
How can you take the child from UK? Where is the order? Here handing how she can hand over?
Lords, the order when
Please now before this court answer how you implement the order.
any date to be fixed,
Why that? We are not already over. You file your petition already dismissed. Where is the question of date fixing? See, you have tried and you want arrest, not happen. You just ignore, your petition dismissed. This is nothing but a ego action against the wife by a husband who is a resident of the kingdom. You want to arrest in India your wife and daughter. Will dismiss your heavy cost. You want to withdraw.
Lord, when stayed in
Take whatever time will impose heavy cost upon charge, coming, going, flight charges. Yes. That is important. Madam, this is nothing but not only harassing the child and your wife, you are misusing the abuse of the cause of the court.
Lord, certainly not. Lord,
What will say now?
certainly not. Lord,
This spend itself, that is over.
Lord says, but the contempt still remains. Lord.
All right.
Contempt of the court.
You argue, will decide.
Disrespect of the
When
respondent to the orders of the court.
you are not implemented, at that time it is only limited period.
We were
Now this is dismissed on what date? Dismissed on what date?
case is dismissed on 11th March 2020. As not contested.
All right, dismissed for default.
That was a petition for custody of the child.
Custody of child.
So he's not interested basically.
They stayed in UK. The
This
child was
clearly depicts now you are not interested.
not, this is not
Madam, what is the limitation for recalling the dismiss for default? Where are you now? You enjoy? You want to withdraw or you want to impose cost? We'll record everything. Don't worry. Just in public time.
He tried everything. From 2016, which he gets the child.
The order dated 27 September 19 spent itself. And the main petition now dismissed. The main petition only for custody. This interim order only visitation rights. Now that the custody itself is dismissed, where is the question of visitation right?
That was only for a period of 5 days.
5 days, that is not also over.
But the court orders are not compliant.
Now she is ready to hand over you today itself 2:30. You are not there. Can court wait? Yes, what do you want? We will dismiss with heavy cost. You can't misuse the court procedure or your personal ego. Person is not there. He want implement sitting in America. We will now implement.
He gave every 15 days once to Bangalore.
Immaterial for us.
Just to meet the child.
Immaterial for us. Immaterial for us. Pass out. You want to withdraw file, ma'am, otherwise dismiss with heavy cost. Misleading. And unfortunately, ಅವ್ರಿಗೆ ಅಂತ ಅಡ್ವೊಕೇಟ್ ಸಿಕ್ಕಿದ್ದಾರೆ ಏನ್ ಮಾಡ್ಬೋದು ಫೈಲೇ ಇಲ್ಲ ಅವ್ರಿಗೆ ದಿಸ್ ಇಸ್ ಹೌ ವಿ ಆರ್ ಡಿಸ್ಚಾರ್ಜಿಂಗ್ ಅವರ್ ಡ್ಯೂಟಿ ನೀವು ವೇಟ್ ಅಮ್ಮ ವೇಟ್ ಮೇಡಮ್ ಬೇಗ ಬರಬೇಕು ಪೊಲೀಸ್ ಆರ್ ವೇಟಿಂಗ್ ಇಯರ್ ವಿ ಕಾಂಟ್ ಅವ್ರ ಕೆಲಸ ಬಿಟ್ಟು ನಿಲ್ಸಕ್ಕಾಗಲ್ಲ ಯು ಆರ್ ಇನ್ ಅಮೇರಿಕಾ 5 ನಿಮಿಷ ಅಷ್ಟೇ ಅಗೇನ್ ಕಾಲ್ 11:30 ಎಸ್ ಕರೀರಿ Government advocate. Where is the accused number 1 and 3? Mr. Government Advocate, where is the accused number 1 and where is that? Where they have done? What is the implementation they have done? ಏನು ಗೊತ್ತಿಲ್ಲ ಅವ್ನು ನಿಂತ್ಕೊತಾನೆ. If you don't know anything, why you are given me file? ಗೊತ್ತಾಯ್ತು ನಮ್ಗೆ, ಅವ್ರು ಹೇಳಿದ್ರು ನಾವು ತಗದ್ವಿ. ಅವಾಗ ಕೇಳಿಲ್ಲ ಅವ್ರನ್ನ 1 and 3 ಅಂತ, ಇವಾಗ ಕೇಳ್ತಾ ಇದೀವಿ. ಏನು ಅಪ್ರೂವೇಟ್ ಹಾಕಿದ್ದಾರೆ? Will have subtracted. What you have done? 1 and 3.
This case, themselves are not in a position to identify the land. One did it.
We are not concerned identity, sir.
When we identify the land, right now we are ready to follow the procedure by acquiring the land.
If you have any difficulty, Mr. Dimaya, if you have any difficulty, what prevented go before the next single judge? Let them there, wait.
Several lands have been acquired, especially this Gundavali and other surrounding villages. In that,
Read the order. The page 89. ಅದು ಬಿಡಿ ಕೆಳಗಡೆ ಬನ್ನಿ. What you have done?
prior to the petition, I did not.
Don't bother fire to we appreciate your sincere work to the nation.
There is no land in that particular area of the land. Yet why is the scale?
You should have come immediately before the court. Though this court directed 6 months to do it, there is no land available, no property available. You can't do anything. What prevented you, sir? You frame the charge. Who are the accused persons? Everybody want to play with the court. Manjunath is present. Manjunath. Where is Jay Prakash? All right, present MD is there. Present MD. Who is Deputy Commissioner Hassan? Tushar Givnath, Chief Secretary. Last time we said accused persons shall be present before the court. We will issue warrant. We are playing with the courts. Our Bhima ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ ಯಾವ ಜಾಗನೇ ಇಲ್ಲ.
The moment issue is running, in that they are claiming that the particular way the petitioner claiming that.
Can you argue before the contempt? Read 7th September 19. If this is your argument, we'll frame the charge today itself. You should approach. What prevented you before the learned single judge? We don't want any respect to submission.
They also may not even let them identify their land. They are ready to approach the land and to pay the cost.
Mr. Order is to consider representation. You should have passed some order. ಹೋಗಿದ್ದೀವಿ ನೋಡಿದ್ದೀವಿ ಯಾವುದು ಲ್ಯಾಂಡ್ ಇಲ್ಲ ನಾವೇನು ಮಾಡೋಕ್ಕಾಗ್ತಾ ಇಲ್ಲ ಅಂತ ಆರ್ಡರ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಇಲ್ಲ ಯು ಶುಡ್ ಕಮ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ದಿಸ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟೆಡ್ ಯು ವೆಂಟ್ ದಿಸ್ ಸ್ಪಾಟ್ ದೇರ್ ನಥಿಂಗ್ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. ಜಸ್ಟ್ ಕೆಪ್ ಕ್ವೈಟ್ ರಾಜಾರೋಷವಾಗಿ ಎಲ್ಲ ಅವ್ರು ನೋಡಿ ಸ್ಟಂಪ್ ಆಗಿದಾರ. ನೀವು ಗೊತ್ತಿಲ್ಲ ರೀ, ಅವ್ರು ಆರಾಮಾಗಿರ್ತಾರೆ. ಯಾರ್ದೋ ಜಾತ್ರೆ, ಎಲ್ಲಮ್ಮನ ಜಾತ್ರೆ, ಇದೆಲ್ಲ ಅವ್ರದ್ದೇ. ಯು ಆರ್ ಫೈಟಿಂಗ್ ಫಾರ್ ದೀಸ್ ಪೀಪಲ್ ಟು ಫ್ರೇಮ್ ದಿ ಚಾರ್ಜ್. ಲೆಟ್ ದಿ ಆಲ್ ದಿ ಅಕ್ಯೂಸ್ಡ್ ಪರ್ಸನ್ ಪ್ರೆಸೆಂಟ್ ಫಾರ್ ದಿ ಕೋರ್ಟ್. The submission will record. Kiran Kumar, learned SGP 1 to 3, Vimaya 2 and 4. Finally, 2 weeks time was sought to implement the order passed by this court. Now you are a different standard. Finally, 2 weeks time is granted for compliance with the order passed by a single judge of this court, failing which accused shall be present before the court, either frame the charge. Will frame the charge. If the court is inclined to impose cost, they are on the accused, same shall have to pay it from the pocket of the accused, not from the government authorities. You will frame the charge against these people. No, sir. You will record a submission, no problem.
The problem is even applicability is not submitting anything. You can let them show their land.
He filed contempt, Mr. Vimaya.
I can understand.
Once contempt filed is immaterial. It is between the court and the contemptor. ಕೇಳಬೇಕು, ಅವನೇನು ಅವ್ರು ಕೈ ಬಿಟ್ಟು ನಾವು ಇದು ಮಾಡ್ಬೇಕು. ಅವ್ನು ನೋಡ್ಬಿಟ್ಟು ನಾವೇನೋ ಪೆನ್ ಇಡಲ್ಲ. ಪ್ರಾಕ್ಟೀಸ್ ಏನೇನೋ ಆಗ್ತಾ ಇದೆ ಈ ಕೋಟ ಇಷ್ಟು ದಿವಸ, ಅದೆಲ್ಲ ಚೇಂಜ್ ಆಗುತ್ತೆ ಇವಾಗ. ಎಷ್ಟು ದಿವಸ ಅದೇ ಪ್ರಾಕ್ಟೀಸ್ ಹಾಕೊಂಡು 2017ರಿಂದ ಇಲ್ಲಿ ಬಿದ್ದಿದೆ ಎಲ್ಲ ಕೇಸುಗಳು. Yes, mister. You are not gone there at all and you file contempt here. And your property is not available. Where your property available? ನಿವೇಶನ 25 ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ? ಅವರಿಲ್ಲ ಅಂತಾರೆ. ಯಾವುದು ಅಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ ಅಂತಾರೆ. Where is your identity, this elector ID card? Election ID card. This is how you are assisting court, sir. ನೀವು ನಿಮ್ಮ ಅಪ್ಪ ನಿಮ್ಮ ತಾತ. Everybody wants to enjoy with the contempt court, sir. Now they are ready. You are not doing. ನಿಮ್ದು ಮನೆನೇ ಇಲ್ಲ ಅಂತ. ಏನು F3 F4 ನಿಮ್ಮ ಮನೆ ಇದೆ ಅಂತ ತೋರ್ಸ್ರಿ. ವೇರ್ ಇದೆ? ನಿಮ್ಗೆ ಅದು ಹೆಂಗ್ ಬಂತು? ಸ್ವಂತ ಮನೆನೋ ಅಲಾಟ್ ಆಗಿದೆಯಾ? ವೇರ್ ದಿ ಸೇಲ್ ಡೀಡ್? ಶೋ ಫ್ರಮ್ ಯುವರ್ ಸೇಲ್ ಡೀಡ್ ಹೌಸ್ ಎಕ್ಸಿಸ್ಟಿಂಗ್. Shall not demand. ಇಲ್ಲ ಅಂತ ಮಾಡಕ್ಕೆ ಹೋಗೋಣ. Frame the charge. We will frame the charge, sir. For ಏನಕ್ಕೆ? If that is the confusion, one ನಿಮಿಷ sir. If that is the confusion, if that is the order passed learned single judge was prevented, you people go people learned single judge. ಎಲ್ಲಿ ಕೊಡಿ, ಇಲ್ಲಿ ಎನ್ಆರ್ಸ್ಮೆಂಟ್ ಕೊಡಿ.
Purchase of the property number 5 is claiming 25. That is
Now read the order. Now you have seen the communication, read the order, last portion.
Page 18.
ಇವ್ರಿಗೆಲ್ಲ ಭಯ ಭಕ್ತಿ ಇಲ್ಲ ರೀ.
If you go to the restaurant.
ಅವೇ ಬರೋ ಹಿಂಗೆ ಒಂದು ಇದು ಎದೆ ಮೇಲೆ ಹಾಕೊಂಡು ಈ ವ್ಯವಸ್ಥೆ. Yes.
Page 89, para 3.
In the above circumstances, the repetition succeeds in part, a record madam was issued to the respondent to the
ನೋಟಿ ಮಾಡಿ ಮಾಡಿ ಮಾಡಿ
even respectively within a period of 6 months in accordance with law, giving into the appropriate judgment dated 13/7/2018 and further made known to the condition result thereof.
When did you make known result thereof to the petitioners? This is 28/10, sir. This is 2019, 6 months. ಏನಕ್ಕೆ will impose cost. Okay? Do you mean ಅವ್ರು ಏನ್ ಬೇಕಾ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೋದು ಅಂತ ಆಫೀಸರ್ಸು? You should have passed or just should have passed orders. ಇವತ್ತು ಮಾಡಿದ ಅವತ್ತು ಮಾಡಿ ಬಿಸಾಕ್ಬೇಕಾಗಿತ್ತು. Only after the order passed by this court. ನಾವು ಸೀರಿಯಸ್ ಆಗಿ ಬರೆದ ಮೇಲೆ ಏನ್ರಿ ಜವಾಬ್ದಾರಿ ಬೇಡವಾ ಇವ್ರಿಗೆಲ್ಲ? ಸಂಬಳ ತಗೊಂತ ತಾನೆ? Whether they're doing their job to the salary? ಅದು ಕರೆಕ್ಟ್, ಇವಾಗ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರು ನೋಡಿ. ಅವರು ಸ್ಯಾಲ್ರಿಗೋಸ್ಕರ ಸಂಬಳ ತಗೊಂಡು ಏನಕ್ಕಪ್ಪ? Now we'll dismiss the contempt petition and impose cost on you. Yes, sir. You have seen the endorsement? Copy ಕೊಡ್ತೀರ ಅವ್ರಿಗೆ? Yes, read the endorsement. 28/10. ಓದಿ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಬನ್ನಿ. ಆದ್ದರಿಂದ ತಮ್ಮ ಮನವಿ ಪರಿಶೀಲಿಸಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ಓದಿ. ನಿಮ್ದು ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಹಾಕಿದಾರ ಅವ್ರು. ಖಾತಾ ನಂಬರ್ 5, 46 ಅಡಿ 35 ಅಡಿ ಮಣ್ಣಿನ ಗೋಡೆ, ನಾಡ ಹಂಚಿನ ಮನೆ ಅದು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಜೊತೆಗೆ 14/4 25 ಚೆನ್ನ ಚೆಕ್ ಬಂದು ಅದೆಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ಲಾಸ್ಟ್ ಬನ್ನಿ. ಆದ್ದರಿಂದ ಓದ್ರಿ.
Second page.
ಎರಡನೇ ಪೇಜ್ ರೀ, ಎರಡನೇ ಪೇಜ್
ಕೆಳಗೆ.
28 ತಾನೇ ಇದೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್.
Second page.
ಸೆಕೆಂಡ್ ಪೇಜ್ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ.
Second page.
ವೇಸ್ಟಿಂಗ್ ಪಬ್ಲಿಕ್ ಟೈಮ್ ಸರ್ ನೀವೆಲ್ಲ. Now, read the order for the single judge. The single judge only says, consider pass orders. Now they pass the order. We are not happy, challenge the tenders. But you will impose cost on these people for delaying the proceedings. 3.5 years. Yes, sir. Benin. Who is the person passed the order? 28/10/2022. You pay cost to the litigation. Reasonable cost ಎಷ್ಟು? 3.5 ವರ್ಷ, 1 ಲಕ್ಷ, 1 ವರ್ಷಕ್ಕೆ. See the smile on the man. ಅವ್ರು ನೋಡ್ರಿ ಎಷ್ಟು ಚೆನ್ನಾಗಿದ್ದಾರೆ. Sir, we are not concerned on person. We are concerned only designation. When did he become the officer of this Hemavati Reserve project? 21. At least 21 6 months ಮಾಡಬಹುದಾಗಿತ್ತಲ್ಲ. ದೊಡ್ಡ ಮನುಷ್ಯ ಆಗಿದ್ರೆ. ಎಷ್ಟು reasonable cost? No. Ask him reasonable cost instead of 3.5 ಲಕ್ಷ. ಅವ್ರು ಕೇಳ್ರಿ. He has to pay from his pocket. The present contempt is filed by the complainants. Take action against the accused persons for willful disobedience of the order dated 7/2/2019, made in WP 29/6/2018, wherein the learned single judge, while allowing the petition, issued mandamus, writ of mandamus to the respondents to consider the petitioner's representation dated 21/5/2011 and 21/6/2018 as per Annexure G and G1 respectively, within a period of 6 months, in accordance with law, keeping in view the aforesaid, keeping in view the judgment of this court dated this court dated 13/7/2018, made in WP 29/604 to 29/608/2018. The said order passed by the learned single judge has reached finality. Admittedly, the respondent accused are not challenged the said order. First of thereby, it is the bounden duty of the respondent accused to consider and pass appropriate orders in accordance with law. When the same was not considered within the time stipulated, the complaint was forced to file the present contempt petition on 18/12/2019. First of this court, when the matter came up before this court on 20/10/2022, this court has taken the seriousness of the matter and observed that this is the state of affairs even after the 75th anniversary of independence. That is how the Karnataka people are treated at the cost of their lives. The accused persons are enjoying without implementing the order passed by this court, even after a lapse of 3.5 years. At that stage, the learned counsel for the accused 1 and 3 and learned counsel for accused number 2 and 4 sought 2 weeks time finally to implement the order passed by this court, failing which the accused shall be present before this court to hear and pay the charge. And if the court inclined to impose cost on the accused, the same shall have to pay it from the particular accused, not from the government authorities. To stop today, the new learned government advocate filed the memo along with the endorsement dated 28/10/2022, stating that in terms of the order passed this court, the authorities considered and passed the orders, stating the property sought in the present situation was not tally. Accordingly, issued endorsement. The said memo along the endorsement dated 28/10/2022 is placed on record. The fact remains, when this court passed the order directing the authorities to consider pass order within 6 months on 7/9/2019. Order should have been passed on or before 7/8/2019. Thereby they have dragged the contempt, the complaint before this court. When this court passed a serious orders on 20th October 2022, now the order is passed after 8 days, that is on 28/10/2022. There is a delay of more than 3.5 years. Clearly indicates the respondents, accused person, have no respect for the court order. Sri Manjunath, learned special land acquisition officer, submits that as on the date of the order passed by this court on 7/2019, he was not in the office. He was not in charge of the special land acquisition officer Hemavati, but he was posted the in charge of the Hemavati only on 21 January 2021. Even if he has not considered passed the orders. The order passed by this court is not against any person, but against the designation. Irrespective of the transfer or the other person who was appointed, they should bound to implement the order passed by the court. Because they are not a party by name, they cannot ignore the order passed by this court. That's how most of the government officers doing. Now the direction should by the court to stop. Though we are inclined to impose heavy cost for delaying the proceedings and dragging the complaint before this court, in the persuasion made by learned government advocate Kiran Kumar, we restrict the imposing cost and impose cost of rupees 30,000 payable by the special election officer from his pocket and not from the government. We will enter the service records also. He is very honest, but not done the job.
Special land officer from his pocket, not the government.
Special land acquisition officer who issued endorsement dated 28/10/2022, within a period of 1 week to the complainant, and produce the endorsement before this court, acknowledgement before this court, failing which the further proceedings will be initiated against him to punish under the provisions of section 12 of the Contempt Court Act for willful disobedience. Full stop. Next para. Though within 6 months ought to have been implemented, but implemented on 28/10/2022, thereby impose cost. It is for the complainant, it is for the complainant to challenge the endorsement dated 28/10/2022 if so aggrieved in accounts with law. In of the above, you pass the following order. Contempt proceedings are a drop, subject to payment of cost of rupees 30,000 for delaying the implementation of the single judge more than 3.5 years. And it needless to observe, it is always open for the complainants to challenge the endorsement dated 28/10/2022 if so aggrieved in accounts with law. Yes, all the, since may not dispose of all the IAS if any, also dispose of not for, yes, Harish. The learned government that case submits that the order passed by learned single judge dated 15th April 2019 is stayed by the learned single judge on when in Angeltirri. Kodi. Avara Kottara is waiting. Yes, Mr. Harish. When? Iburu Gotela, Maka. Stayed by the learned single judge, as said by the learned government pleader. Same is not disputed by the learned counsel for the complaint. Submission place on record. Oh, you have said your writ appeal prepared. Dismiss. Therefore, 6 2 weeks time to comply the order. Where is that again? The inspector of the order of this court dated 20th, in person, order of this court dated 20th October 2022, Kiran Kumar Learned Government pleader submits that the appeal filed by state dismissed on 13th and 2022. Within a week, will regularize the service of the complainant. The said submission place on record. Call the matter next week. Yes, na Sanjay. Buddy. Yes, what happened? Implemented. Yes, sir.
I purchased the property, both the properties by way of a single selling, and the expedition also was for both the properties. The contempt is also for both the properties. And look at the order. Immediate order says,
Your last occasion, you asked question to you whether his name entered in respect of Surveillance Party 1 even prior to the order of Deputy Commissioner dated 26/5/2015. Finish. Kodi. Clarification ಬೇಕಾಗಿಲ್ಲ. Prior to the order of Deputy Commissioner, your name was entered in the RTC in Surveillance Party 1. They are bound to comply. Kodi. Aste point. What submission, sir? We know your submission. Prior to the order of Deputy Commissioner, whether your name entered in the order or
That is
not.
not the order of the CH. When you take the order of CH, what?
All right, read.
Just clarify.
Read.
Page 173 of the resolution.
Yes.
Point number 2, on the basis of various reliefs offered or given in law service status, the relief is voted after the action made to preempt unnecessary litigation between the petitioner and the state.
ಓದ್ರಿ ಗೊತ್ತಾಗುತ್ತೆ ನಮಗೆ.
The revenue authority, municipal authority, consider making appropriate entries in the name of the petitioner upon representations being made in accordance with law and as per the applicable.
Mr. Nair, 1 minute, sir. This order was passed keeping in mind earlier all the petitioners never entered the orders passed by the revenue authorities. The Deputy Commissioner order dated 26/2/15, everything is removed. That is the grievance of all the petitioners. The order is enter their name. Since 1 minute, sir, since you have removed their name in pursuance of the Deputy Commissioner order, we are just asking you, as on the date of the order of Deputy Commissioner, your name was entered, they are bound to enter. Otherwise, you have to go.
That is one aspect with regard to surrender, with regard to 6 Gunda.
That's all.
With regard to 4 is the 34 Gunda.
That are they are done.
Now they issue a new RTC. They made 18 Gunda the Karnataka. I find in the statement of objection that rather than Apani of 2001, 2002, where there is no corruption. Now all of a sudden, then the statement of
On the last page, ಹಾಕಿದ್ದೀವಿ. But the order of the court was to consider the representation in accordance with law. Court is resting order. The remaining extent was found to be 18 Gunda.
Sir, ಅದು ಅರ್ಲಿಯರು ಡೆಪ್ಟಿ ಕಮಿಷನ್ ಆರ್ಡರ್ ಮಾಡಕ್ ಮೊದಲು ಅವ್ರ ಹೆಸರು ಕರ ಬಿತ್ತಾ ಇಲ್ವಾ? Simple. Don't try to interpret. Everybody wants to interpret their own whims and fancies. His case is prior to the Deputy Commissioner order, my name was entered this industrial property, including Karab. Now that Deputy Commissioner was enter his name, it should go along as it is. You can't bifurcate now merely because you've done survey. You should have challenged the order. If you have done survey, very aeration, you should have challenged the order for one single judge. Restore what it was. That is the order.
After doing 48 survey reduced. RTC application survey was restored.
ಸ್ವಲ್ಪ ಇರ್ರಿ. You should have gone before learned single judge. ನಿಮ್ಮ ಆರ್ಡರ್ನು ವಿತ್ ಸ್ಪಿರಿಟ್ ನಾವು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಎಲ್ಲ ಚೇಂಜಸ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಚೇಂಜ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ಬೇಕು. Get the RTC as it was. No question of single judge is already confirm ಆಗೋಗಿದೆ ಅಲ್ಲಿವರೆಗೂ. ಮತ್ತೆ ಇವಾಗ ಎತ್ತ ಮಾಡೋದು. ನಿಮ್ಗೇನ್ರಿ ಖರಾಬ್ ತೋರ್ಸ್ರಿ. ಈ ಕಾಂಟ್ ಎನಿಥಿಂಗ್ ಗವರ್ಮೆಂಟ್ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ತೋರಿಸಿ, ಅವ್ರ ಆರ್ಟಿಸಲ್ ತೋರಿಸಿ, ಆಮೇಲೆ ಸಪರೇಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಯು ವಾಂಟ್ ಟು ಪ್ರೊಟೆಕ್ಟ್ ಖರಾಬ್ ಲ್ಯಾಂಡ್, ಪ್ರೊಟೆಕ್ಟ್. ಎಂಟರ್ ದೇರ್ ನೇಮ್ in accordance with law prior to the order of commissioner. At the so far the other one show.
It is the same piece of land.
We are not concerned.
Same piece of land. Only 6 Gunda in front.
If you don't answer the court query, then they'll do one for you. Your name is not there. 1, 4, done. Survey number 17, they will do the job. Not survey number 41. Your name is not there. As it is, ಏನಂತ ಅದು told me separate ಮಾಡ್ಕೊಳ್ಳಿ. Mere entering your name in the RTC, you won't become a owner. You can't become a owner based on the RTC. RTC is not a title document. At the request of Learned Council for the Learned Government Pleader, to ensure the corrupt should be part and parcel of Survey 17.
No, it's not there.
ಹಾ ಮೊದಲು ಏನಿತ್ತು ಆರ್ ಟಿ ಸಿಯಲ್ಲಿ you should clarify the RTC as per R2 next date appearing. ಇದು ಆಗದ ಹೋದ ಕತೆ ನಾವು ಚಾರ್ಜ್ ಪ್ಲಾನ್ ಮಾಡ್ಬಿಡ್ತೀವಿ ಅಷ್ಟೇ. Yes, Rangnath Joyce.
My lord, I pay for the complainant, my lord.
We want to settle their scores in the contempt. ನಮ್ಮ ಮುಂದೆ ಆಗೋದಿಲ್ಲ. Yes.
Lord, page number 10, there was a direction and undertaking by the government.
Yes, Mr.
For page number 20, para 6, regarding seniority, my lord.
Where is the complaint, sir?
They have filed an affidavit, my lord, that the committee has been, the committee to which it was referred and where AGA himself undertook that committee will consider that committee was not there antare. Ega now regarding clarification of the order, they have filed an application before the division bench in WP number 7299 on 28th October. 28th October file ಮಾಡಿ ಈಗ ಅವ್ರ ಹತ್ರ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Petitions as disposed of by directing the committee constituted as the order dated 11/11/2019 to consider the objections as referred in now. Expediently delegated in the order of 16 from the date of
As on the date of the order, whether the committee was existing or not.
As on the, it was
ಸ್ವಲ್ಪ ಇರ್ರಿ. Then you should have moved before Leonard single judge. ಅವಾಗಲೇ 22 ವರ್ಷ ನಿದ್ದೆ ಮಾಡ್ಕೊಂಡು ಇರ್ತೀರಿ. ಅವ್ರು ಮಾಡಿ. The Leonard Council, Leonard Government Advocate submits that as on the date of the order passed by the Leonard, the Coordinate Bench, that 15th October 2020, the committee was not existing. Thereby they have filed application for clarification. Submission plus on record. All up to 2 weeks. Yes, Govindraj. Yes, what happened? Yes, sir. Yes, page 47. Yes.
We are therefore reviewing that the issue of the evidence in the conclusion that all contact of the extension of base case cannot be accepted. We accordingly suggested the law of the evidence in the as a consequence, we hold that the appellate will be entitled for extension of the base case and direct the benefits that have approved them pursuant to the order of the Enrollment Commissioner so to work them within a period of 3 months. Now, the affidavit filed is in the act under the rules, the budget allotment is confined to 35%. Therefore, it's like saying, I have suffered a maintenance decree, but I don't have money, therefore I will not pay. And that is directly they have been saying it on several times that yes, there is order, but I will not pay. Therefore, it's a matter for framing
Yes,
the
sir.
charge. Whatever it is, let it be.
Yes, sir.
Order dated 5/4/2006, passed by the Commissioner, was directed to the nothing more, nothing less. Page 48 is the order of the Commissioner. What the Commissioner did was, Item 6 referred to as page 48. The not under the act and it existed then.
Yes.
Proposal to sanction any pay scale or any allowance to the employees of the canton and employees of the education institution managed by the canton. After have the approval of the commission. Canton passed a resolution cited by page item 4 at page 48. Then there was some confusion. Thereafter, an advisory committee.
Page 53 Ban Rajgopal. Page 53.
Page 53%. A team is government order to move from the area to India. The people who ದೇವರ ಆಡಳಿತ ಪ್ರಧಾನ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ತಮ್ಮ ನೇತೃತ್ವದ ಜಿಲ್ಲಾ ಕಮಿಟಿಗಳ ಶೈಕ್ಷಣಿಕ ಸಂಸ್ಥೆಗಳ ಕಲಾವಾರ ಸಮಿತಿಯ ದಿನಾಂಕ 24/2000 ಶಿಫಾರಸು ಮಾಡಿದಂತೆ ಈ ಘಟನೆಯಿಂದ ಅಗತ್ಯ 14 ಪ್ರಸ್ತುತ ಕಾಲೇಜಿನಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ 13 ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ದಿನಾಂಕ 1/1/2022 ಆಗುವಂತೆ ಪರಿಶುದ್ಧ ಪಾಲನೆಯನ್ನು ಮಂಜೂರು ಮಾಡಿದೆ. What ultimately it ordered was the advisory committee's recommendation dated 24/10/2002.
Yes. Not 24, 5/4/2006. The division man says implement the order dated 5/4/2006.
24/10/2002 resolution of the advisory committee.
They are not concerned.
Thereafter,
Ultimately, the annexed B came to pass by the.
came to be passed approving the resolution of the advisory committee.
All right.
Resolution of the advisory committee in respect to the 3 persons was that BVJ pay scale should be granted in accordance with the government orders. Now,
The writ of it is being ordered.
One minute.
I have an excellent case, but I have an
All right, all right.
You have an excellent case, or I may have a case. That's
All
what
right.
you decide. Now kindly see the last paragraph of the order. Page 47. As a consequence, the board and the applicants will be entitled for extension of
Revised UGC pay scales and
the next sentence, next part is important.
hmm,
Directed the benefit that have accrued to them pursuant to the order of the endowment commissioner dated 5/4/2006 being given to them within a period of 3 months from the date of the respect of the
yes,
The division bench uses the word accrued. There is our understanding of the
yes,
because by then revised statutory rules had come into effect. Because the order of 2002 was on at the time when there was no statutory framework for governing the pay scales of employees of temples and temple aided institutions. 24/12/2008, the government 2018, a revised rule came into effect.
when
24/12/2018.
that is as on the date of the order pass, prior to the order pass by the required bench.
Prior to the order passed by this court, that is the reason why we want the division in the last sentence said that place the revised rule also before. They said, whatever is approved you pay. Because from 24/12/2018, they will not be covered by the.
Whether you have paid the accrued.
After 24/12/2018, whatever was due, we have paid according to the scale. Thereafter, kindly see 70 C.
Hmm.
In the business and enterprise. So the statute rule is operating, which grants them the benefit
If
of.
you are not in a position to implement the order passed by and bench, you should have challenged that order. Or
No, I am implementing the order. That order, it's an order of the commissioner itself stands modified by the statutory rule. Because statutory rule says.
then only remedy for the accused persons to go for the learned single judge. This order we can't implement. This is the statutory provision. Rajgopal, we can't ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. Scope of the contempt is very, very limited. We can't interpret the order.
That's what exactly.
If the order is wrong, cannot be implemented. Only remedy to SLP or for because the same judge. Yes.
Can they have a look at the rule?
Fine,
And it
what
was
happened?
approved. Division bench, if it wanted future also, in spite of the rule, I have to pay.
Please challenge that order. That is wrong against the rule. Should have challenged that order. Kodi.
On the day the order was passed to the commission, that court was not enforced. That rule, on the day the General Secretary allowed the dismissal petition, that rule was not enforced. Rule has come during the pendency of the writ appeal. And because of this rule, I am unable to implement.
Yeah, when the argument advanced by both the parties, the rule
No
was
rule was advanced, no argument was advanced on rule one.
then
The question was-
challenged before the appellate court.
the question was whether the 2006 order of the commissioner is valid. Then it said it is valid. It is not that once an executive order is said to be valid, it will be valid for all times to come. Rules may change. Rule has changed on 24/12/2018, by which the employees of all the colleges run by the temple management will be eligible for electric tax care, subject to the condition of Rule 17 capital E.
That is not there in the order.
First, the rights of the parties are decided as on the date of entering the court. Subsequent change of rule causes me disability from interpreting the rule.
You should have to go before the same judge, same bench, get the clarification. This is the problem. We can't implement.
If it is for them, in spite of this rule, if they are attacking, it is for them to go before the appropriate forum and say,
All right.
this rule is not applicable to us.
Abba, section 11, 12 ಕೊಡಿ. ಕೊಡಿ ಅವ್ರಿಗೆ. Please read section 11, 12 contempt quota. We can't go against it, even a wrong order.
That's what I am saying.
Rajgopal, we know your case. According to you,
Even though I am implementing the order,
no, Mr.
subject to
Rajgopal.
statutory rule.
Rajgopal, according to you, when the order passed learned single judge on 17/7/2018, the rule was not existing. The writ appeal pending, in pendence of writ appeal, a rule came to existence on 24/12/2018.
Yes.
That the concerned respondent counsel ought to have brought notes of the division bench.
No,
One minute, sir.
The appellant who is the respondent, he himself places that rule on the record.
Keep in spite of the rule, proceed.
That is not-
One minute, sir. Proceeded.
That is the reason, my lord. In the last paragraph, the Indian bench uses the word approved. Future payments okay, because they benefited approved to them from 1/10/2002.
ಅದು ಡೇಟ್ ಆಗಿದ್ರೆ ಬೇರೆ ಆಗಿರೋದು ಡೇಟ್ ಹಾಕಿಲ್ಲ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಎಂಡೋಮೆಂಟ್
Approved according to.
endowment commission at 12/46.
Spent itself in the commencement of the rule. Therefore, in the last paragraph,
If that is so, there was no the necessity to issue such a direction.
approved matter, whatever was approved, till date you pay it, which I have paid.
ಹಂಗೆ ಹೇಳಿಲ್ಲ ಅವರು ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ Only writ appeal allowed. To that extent, modified the order of the learned single judge. All right.
By
Then we will
virtue
claim the
of
charge.
amendment, the new rule having come into force, I am disabled from implementing it.
Yes. Bob. The claiming the charge, sir. We'll claim the charge, then we'll try ultimately if we succeed, we'll see. Bob. The learned senior counsels for the parties before claiming the charge. Sri Jayakumar's party, learned senior counsel, contended that the present contempt petition is filed by the complainant for willful disobedience of the order dated 17/3/2021, made in writ appeal 26/74/18 connected matters, wherein the co-ordinate bench of this court, while setting aside the order passed by the learned single judge, dismissing the writ petitions, held that the appellants would be entitled for extension of revised UGC pay scale and direct the benefits that have accrued to them pursuant to the order of the Endowment Commissioner dated 5/4/2006 to be given to them within a period of 3 months from the date of the receipt of certified copy of the judgment. The said order passed by the coordinate bench has reached finality as the accused has not implemented up to 24/12/2008. Yes. That is the order passed. ಆಮೇಲೆ ಮಾಡಿಫೈ ಆಗಿದೆ ಅಂತ ಅದೇ ರೂಲ್ ಬರೋ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಮೇಲೆ ಕೊಡಕ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳೋದು. ಆಯ್ತು reached finality since the order is not complied. Whether you have disclosed or received up to 24/12/2018?
Yes, we have filed a memo.
ಅಲ್ಲ ಅವರು
This is the SLP dismissed ಆದ 3ನೇ ದಿನ ಕೊಟ್ಟಿದೆ.
Oh, you have filed the SLP na?
SLP ಫೈಲ್ ಮಾಡಿ
ನಿಮಿಷ ಅಮ್ಮ.
ಅದೇನ್ ಫೈನಲ್ ಬಂದಿದೆ.
Finality when the SLP number ಕೊಡಿ ರಾಜಗೋಪಾಲ್. SLP number so and so dismissed by the Honorable Supreme Court on so and so date. To stop. Thereby, he would contend that the order passed by the coordinate bench has not been deliberately intentionally obeyed by the respondent. Thereby, action has to be taken. Contempt proceeding has to be initiated against them. Therefore, it's a pit case to claim the charge. For contra, Sri Rajgopal, learned senior counsel for the accused, would contend that as on the date of the petition filed by the petitioner, the rules Karnataka, which rule ado? ಯಾವ rule Rajgopal?
17. The rules, the Karnataka Hindu Religious Institution Charitable Endowment Rules 2002, Chapter 4A, Rule 17C and 17E.
17A and C. E na?
17C, 17 capital C and 17 capital A. Capital E.
Rajgopal. Dismissal. The Rajgopal and the of the respondent. Was not in existence. Thereby, the petition rightly dismissed by the learned single judge on 17/7/2018. Even on that day, rule was not existing. During the pendency of the writ appeal, the Rule 17C and E, Chapter 4A of the Karnataka Hindu Religious Institutions and Charitable Endowment Rules 2002 came into force with effect from 24/12/2018. Accordingly, the amount payable, the pay scales payable to the complainant has been paid after the contempt petition filed before this court. Paid up to 24/12/2018. And the complainant is not entitled to receive the pay scales from 24/12/2018 onwards in view of the prohibition of rule stated supra. Thereby, after 24/12/18, it cannot be implemented. Therefore, he sought to dismiss the contempt petition. Next paragraph. Having heard the learned senior counsel for both the parties, the only point that arises for consideration in the present contempt petition is whether the complainant has made out a case to frame the charge in the peculiar facts of the present case. It is undisputed fact that the petitioner waived the prior writ petition you have not produced the writ petition copy. Where is that? No, admittedly, the present accused filed writ petition 8044/245/2010 challenging the order dated 5/4/2006 passed by the Commissioner for Hindu Religious Endowment Institutions, Charitable Instrument, State of Karnataka, Tipu Sultan Palace Road, Chamrajpet, Bengaluru 18. The learned single judge, after hearing both the parties, allowed the writ petition filed by the accused and quashed the order dated 5/4/2006 issued by the passed by the Commissioner Endowment. Agreed by the said order passed by learned single judge. The complainant filed writ appeal 2674/2018 along with the other appellants. Along with the others. The division bench of this court by the order dated 17th March 2021 allowed the writ appeals, and the order passed by the learned single judge dated 17/7/2018, made in WP 8044 to 45/2010 was set aside, and writ petition filed by the present accused came to be dismissed and specifically held as under para 69 and 70 as under. Full stop. The grievance of the complainant that though after the contempt petition filed, the amount payable in terms of the order dated 5/2016 paid UGC pay scale payable, UGC pay scale payable to the complainant was paid in terms of the order dated 5/2016, paid only up to 24/12/2018, but subsequently not paid. Therefore, the present contempt petition is filed. To stop, it is the specific contention raised by the learned counsel for complaint. The order passed by the coordinate bench is not restricted to up to 24/12/2018, nor the order dated 5/4/2006 passed by the UGC scale, passed by the Commissioner Commissioner of Individual Endowment. Thereby, it's a clear case of contempt. Though Sri Rajgopal Learned Senior Counsel would contend that in view of the Rule 17 capital C and E of the so and so rules of the Karnataka Hindu Religious Institution and the Charter of Endowment Rule 2002, the accused is unable to implement the order passed by the division bench. If that is so, division bench must have admittedly the order passed by the coordinate bench in writ appeal 26/70/2018 and corrected matters dated 17th March 2021 was subject matter SLP. Subject SLP 10,977 to 10,980 of 2021 before the Hon'ble Supreme Court. The Hon'ble Supreme Court, by the order dated 2/8/2021, had dismissed the SLP. Thereby, the order passed by the coordinate bench has reached attained finality. Full stop. If there was any prohibition or implement the order passed by the coordinate bench, the accused ought to have urged before the, whether you have taken such content before Supreme Court, implement ought to have urged before the Honorable Supreme Court or before the coordinate bench where the order is passed. Once the order passed by this court has reached finality, holding that the appellants are entitled extension of revised UGC scales and the benefits that have accrued to them pursuant to the order of Endowment Commissioner dated 5/6/2006 should be given to them within a period of 3 months. The accused are bound by the order. Mere subsequent interpretation, subsequent amendment of rule, they cannot disobey the order passed by the coordinate bench. It is for the accused at that time to have approached the appropriate bench as soon as the Rule 17C and 17E came into force on 24/12/18. That too prior to the order passed by the coordinate bench on 17 March 2021. This court, the scope of the contempt under the provisions of section 11 and 12 is very limited, cannot go beyond the order. First of in of the above, we have the considered opinion, the fit case to prep the charge and proceed in accordance with law. First up, next para. Post this matter, next week, the accused are directed. Only order, section 19,
Section 19.
only order.
Order to frame charge.
All right.
Therefore,
At this stage,
4 weeks are
at this stage, learned senior counsel for the respondent seeks time on the ground the accused intend to file appeal for framing of the charge. Submission placed on record. Adjourned by 2 weeks, 3 weeks. Yes. Yes, sir. Correct.
Passed over matters, still number 8.
Yes. Dismiss your fiction on merit. We don't want any instruction from you. Bunny. Madam, court is meant for the litigant. We can accommodate the lawyer, not the litigant. If he's sitting in America, can you wait for him? You'll pass orders. No, ma. We accommodated you to 5 minutes. You are as requested by you. You can't dodge. That's all. Dismissing with cost. Mama. No, madam. Hey, dismiss part, deep part of the case of being a counsel, you should apply your mind. You claim that the not battery. Bama. The complainant filed the present contempt petition. The complainant husband filed the present contempt petition to take action against the wife accused for willful disobedience of the interim order dated 27/9/2019 made in GNWC 60 of 2018 on the file of the third additional family judge Bengaluru, wherein the honored judge of the family court was allowing application 14 dated 5/9/2019 partly directed the respondent accused Devakumari to hand over the minor child Shruti to the custody of the petitioner from 30th September 2019 to 5th October 2019, 6 days, September 30th, for a period of 5 days before the Deputy Director of Bengaluru Media Center without bail. And thereafter, the respondent is directed to bring the child to Bengaluru Mediation Center at 11 a.m. on 30/9/2019, and the BMC Deputy Director is directed to make the arrangements for handing over the child, the named suited petitioner from the respondent. To stop. Further, the family court directed the present complainant to re-hand over the custody child to the respondent wife between 3 p.m. to 4 p.m. on 5th October 2019 before the Deputy Director, Bangalore Media Center, without fail. To stop, it was made clear that if the respondent wife fails to hand over the custody of child smoothly in favor of the petitioner, then the judicial police are directed to give the assistance through women police to enable the petitioner to take the interim custody of child in a smooth manner. And also permitted the respondent mother to have a touch with the child every day morning and evening about 10 minutes through phone stroke video calling on the said 5 days. And further directed both the director of the complainant to take all necessary steps to see that child stay with him in his native place or Bengaluru, which is comfortable to the child, and take note of age, likes, dislikes of the child while exercising custody utilization rights, and directed not to compel the child to do any acts against her wishes or not to give any such food against her likes and taste, and further directed the complainant not to give ill advice about the respondent mother to the child while exercising custody rights. The petitioner was also directed not to take the child out of the country and not return the child with him after completion of 5 days. The present contempt petition came to file on 22/10/2019 after expiry of 5 days. To stop, as per the order passed by the family court, if the respondent or mother fails to hand over the custody of the child smoothly in favor of the petitioner, then the judicial police are directed to give their assistance to the women police to enable the petitioner to take the interim custody of the child in a smooth manner. In all fairness, the present complainant, being the father, had to approach judicial police for assistance of women police, enable him to take the interim custody of the child are directed by the family court. Unfortunately, no such things has happened, nor brought to the notice of the family court that in spite of the approach, he approached the judicial police to give assistance through women police, and police have not assisted. He is not a case. To stop. When this court and the matter heard this course on 18/10/2022, case called twice. None appears for the neither accused present or filed reply, nor the counsel. Therefore, this court issued an Hon'ble warrant to the accused to the judicial police, returned by today, 3rd November 2022. Accordingly, or essentially, accordingly, the judicial police by name Anupama M, probationary PSI, and Saubhagyamma Saubhagyamma R, WSC 7207, promptly implemented the order and produced the accused before this court. To stop. The accused who appeared before this court in person along with the lawyer absconding. On the first when the case was the first morning session, when the case was called. Now, when the case was called second time, blissfully the counsel for the accused is object. The accused made a statement before the court that She is ready handing over the child at that time, but there was a miscommunication. She never disobeyed the order. Post up. The submission placed on record. The fact remains that when the order passed by the Family Court on 27 September 2019, directing the wife to hand over the child from 30th September 2019 to 5th October 2019 for a period of 5 days before the Deputy Director of Bengaluru Media Center without file. The order was clear. If fails to hand over the custody of the child smoothly in favor of the petitioner present complaint, then we should have approached the jurisdictional police as directed by the family court for assistance through women police, enable him to take the interim custody of child in a smooth manner. 5 days granted by the family court, lapse long back, 2019, 20. 2 years, more than 2 years. And subsequently, since the very petition filed, subsequently, the very GNWC 60 of 2018 filed by the present complaint came to be dismissed for default on 11/2022 and no application is filed for restoration, and the main petition is filed for custody of the child since he is not pursuing the main prayer and not order and not obeyed and not taken any steps in terms of the order of family court, comma, to approach the judicial police for taking the child smoothly, comma, the present contempt is filed against the wife, not only harass the wife and the child, and admittedly, as stated by mother, the child attained puberty on which date? 22nd September 2022. Now, those circumstances, the child who attained puberty should be with the mother, and admittedly, the appellant is not in India, he is residing at where? At 208 Bathhouse, number 5, Arboretum Place, Barking, Essex, 1G 1111 PS 21, United Kingdom. Though ordinary resident of 3/67B, Kamala Milliam, Dr. Radhakrishnan Salai, Palavakam, Chennai 41. But learned counsel for the complaint rightly, fairly, Madam so and so submits. Now husband today is in America. No steps is taken to recall the GNWC 60 of 2018 dismissed for default on 11/2022, which reached finality. Therefore, no contempt is made out, and the present contempt petition is filed, misusing and abusing power of the court. Thereby, we are inclined to dismiss the contempt petition with cost. To stop, since the rights of the minor child is involved, parents should act with responsibility. Because of their ego between the husband and wife, the child should not suffer. And taking advantage the order passed by family court without implementing its true spirit, directed family court has approached this court in 2019 and wasted from judicial time and abused the process of court. Thereby, he is liable to dismiss with cost of rupees 50,000. Contempt is liable to dismiss with cost of 50,000, payable by the complainant to the child by way of deposit in the name of child by way of deposit any national bank within a period of 1 month.
No occasion for him to execute this order, further it is not we ignore the order.
Madam,
Despite
if
the
you
fact-
argue further, in spite of reading the order again, read again page 31 order. You should not have come to the High Court.
in respect of
We will
that-
impose 1 lakh, 1 lakh. 1 lakh payable by the complaint by way of deposit, fixed deposit in the name of the minor child. ಏನು ಹೆಸರು ಹುಡುಗಿ ಹೆಸರು? Shruti, till she attain majority in any nationalized bank, and a receipt of deposit shall be paid before this court within a period of 4 weeks, failing which the office director for this matter to proceed to punish the complainant for taking a raid on the court, not only the raid on the court, but also raid on the child as well as the wife. Yes. The prompt action taken by the PSI, Srimati Anupama, Miss Anupama, Bhagya, your Srimati, Bhagyamma R, HWC 7202, to implement the order passed with this court, dated 18/10/2022, is appreciated and placed on record. The police are directed to set at liberty to the accused. No? Srimati Devakumari, forthwith. Madam, next time if you disobey, you will pay 1 lakh here. Advocates Association. Yes. Next case. Yes, sir. ಯಾವ್ದು ಸ್ವಲ್ಪ ಉಪ್ಪು ಖಾರ ಹಾಕ್ತೀನಿ ಅಮ್ಮ ಸ್ವಲ್ಪ ಉಪ್ಪು ಖಾರ ಹಾಕ್ತೀನಿ ಏನು ಮಕ್ಕಳು ಐಡಿಯಾ ಜಯಶ್ರೀ ಎಸ್ ಶ್ರೀನಿವಾಸ್ ಪಾಸೋ ಎಸ್ ಪ್ರಕಾಶ್ Yes, what is this? Where is the order? Read. Huh. When? Twenty-six. Raise objection. Yes.
Heard and not heard.
Ah.
I submit that I request to the BVJ was informed of the
Read paragraph 3. Ah.
I submit that I request our therefore
What is mean by that? As I have done in several cases. If that is so, you should have challenged immediately the order for the single judge. Let him finish. Where is the writ petition? Where is the writ petition filed by you? Yes, sir. Hmm. Ah. Hmm. That we are not concerned, sir. No, what is challenge is only 7th June. Hmm.
this one petition was restricted to the next year. And kindly see, literally,
Hello, what do you want to say, sir?
literally, in this case, kindly see, page 23. Page 23.
Hmm.
Page 23 and the senior consists also. The senior consists also of the BVJ. And the BVJ also of the
Yes, Wadi. Hello.
This is also one such case.
Correct. No problem.
Now,
Do you mean to say 7th June 2021, the learned judge just followed the earlier order dated 20th January 2021.
13.
Ah.
Page 13.
Ah.
Internal page 2 of the order. Paragraph 200.
Yes, yes.
Paragraph senior person. I'm not going to authority in this matter. It is all type of copy.
It's all right.
Why is this copy served on me? All the PDF.
Sir, that is your specific ground. Now you have come to your objections.
Yes.
Please read the paragraph 5.
I will read from paragraph 3.
No, paragraph 5 enough.
I will read from paragraph 3.
Not necessary, sir.
Permit me to read from paragraph 3. Thank you for permitting me to read.
See the audacity of your deputy, your commissioner. Paragraph 5 ಓದ್ಬಿಡಿ ಗೊತ್ತಾಗುತ್ತೆ. ಅದು 3ನೇ ನೀವು ಹೇಳಿದ್ದಲ್ಲಿದೆ ಅಷ್ಟೇ. ನೀವೇನು ಹೇಳಿದ್ರು ನಾಟ್ ಬಿನ್ ಹರ್ಡ್. ಆ ಸೆವೆರಲ್ ಕೇಸ್ ತರ ಮಾಡಿದ್ದಾರೆ ಅವೆಲ್ಲ ಅಲ್ಲಿದೆ. ಪ್ಯಾರಾ 3 and 4 ತಾವೇನು ಹೇಳಿದ್ರು ಅದಿದೆ ಅಲ್ಲಿ. ಆಯ್ತು ಓದಿಪ್ಪ. ದಯವಿಟ್ಟು ಓದಿ. ಓದಿ.
In terms of their order, disclose the subject. Include ಮಾಡಬೇಕು. ಯಾರಿಗಾದ್ರೂ ಕಾಪಿ ಆದ್ರೂ ಕೊಡಬೇಕು. ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದು BVJ ಆದ್ರೂ.
That's how, sir, both the complainant lawyer, the accused lawyer and accused and complainant, they are playing with the court. Everybody wants to play with the court.
They are not playing lightly. Here for 2 minutes.
Take your own time, sir, 2 hours, no problem.
Copy the survivor, petition copy, lawyer.
That we can't decide now in the contempt.
Petition copy.
ತಾವು ಹೇಳಿದ್ದು ಸತ್ಯ. You should have gone before Leonard Singhal immediately before demolition. Read paragraph 5 now. ದಯವಿಟ್ಟು paragraph 5 ಓದಿ ಸರ್.
Demolition order ಹೋದಾಗಲೇ ನಮಗೆ ಆರ್ಡರ್ ಕಾಪಿ.
ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ಓದಿ ಸರ್. ಓದಿ. Please read.
I submit that I have inferred from the paragraph 5. I submit that I have inferred from the ingredients of the BVJ. I was informed at the time of demolition of the new structure of the under 80 of the complainant showed a copy of the order passed by the Honorable Deputy Number 4. So, upon the removal of the said order, it was noticed by the officials that the same did not contain the schedule, nor any site number, etc. And there was no particulars of description of the property in any portion of the order. When the officials pointed out the same, the complainant was unable to explain. Therefore, in the absence of any particulars, that is no option. While carrying out the demolition work of the all of the unauthorized structures in the area, the unauthorized structure of the complainant was also demolished.
We want a simple question to you, ready? If on the date of before demolition of the building, if somebody came with the court order with the same number, where
no
the
same number.
Same for 9450.
No. That is the number. Order copy ಕೊಟ್ಟಿದ್ದಾರೆ schedule ಕೊಟ್ಟಿಲ್ಲ.
ನಿಮಿಷ ಸರ್ ಸ್ವಲ್ಪ ಕೇಳು ನಮಗೂ ಸ್ವಲ್ಪ ಅವಕಾಶ ಕೊಡಿ.
Order copy schedule ಇಲ್ಲ.
ನೀವು ಹೇಳಕ್ ಬಿಟ್ಟಿಲ್ಲ ನಾವು ಕ್ಯಾನ್ ಪ್ರೊಸೀಡ್ ಫರ್ದರ್. ಸ್ವಲ್ಪ ನಮ್ಗೆ ಹೇಳಕ್ ಬಿಡಿ. Now they have produced the order dated 7th June 2021, WP 9450/2021, containing their names as complainants, petitioners, your names, including advocates' names who appeared, according to you not appear. Can your officers can't wait, verify?
There is nothing which
Please come to the petition now.
Petition is not served on us.
ಅದನ್ನೇ ನೀವು ಇಷ್ಟೆಲ್ಲ ಬುದ್ಧಿವಂತರಾಗಿದ್ದವರು ಸ್ವಾಮಿ ರಿಟ್ಪಿಸಿ ಕಾಪಿ ಕೊಡಿ ಸ್ವಾಮಿ ನೋಡೋಣ ಶೆಡ್ಯೂಲ್ ಬೇಕಾಯ್ತು.
ಅವ್ರು ಕೊಡ್ಬೇಕಲ್ಲ.
ಅವ್ರು ಬುದ್ಧಿವಂತರಲ್ಲ, ದೊಡ್ಡ ಮುಂಡೆ ಬಾಬು ಕೊಟ್ಟಿಲ್ಲ.
ನಮಗೊಂದು ಆರ್ಡರ್ ಕಾಪಿ ಎಲ್ಲಾದ್ರೂ ತೋರಿಸ್ತಾರೆ ಡೆಮಾಲಿಷನ್ ಹೋದಾಗ.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ. ಯು ಶುಡ್ ಹಾವ್ ಸ್ಟಾಪ್ half an hour. ಪ್ರೊಡ್ಯೂಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಿಮ್ದು ಓದ್ತಾ.
ಅದನ್ನ ಡೆಮಾಲಿಷ್ ಮಾಡಿ you was not able to furnish all the copies. That is what I am saying in paragraph 5.
That we can say, sir.
If only you are given us the copy of the writ petition, if only you are served it earlier to the lawyer, or if only you are given a copy of the order to the Bangalore Development Authority, or something like that, saying the report that this was authority.
All right.
Nothing is produced. Nothing is given to the lawyer. Retribution copy is not there at the time of disposal, even after the disposal of the retribution also copy is not
Sir,
there.
we are just asking you, before demolition, can't wait upon 1 hour. You should have asked.
Painted.
No. You should have asked. Retribution copy. All fairness, copy ಕೊಡಿ ಇಟ್ಟದು ಅಂತ.
Paragraph 5 ಅಲ್ಲಿ he was not able to explain ಏನು ತೋರಿಸ್ತಾ ಇಲ್ಲ ಕೋರ್ಸ್ ಶೆಡ್ಯೂಲ್ ನಿಮ್ದು ಸೈನ್ ನಂಬರ್ ಏನು ನಿಮ್ದು ಯಾವುದು ಏನು ಅಂತ ತೋರಿಸಿ ಅಂತ ರಿಟ್ರಿಬ್ಯೂಷನ್ ಅದು ತೋರಿಸಿ ನಮ್ದು ಶೆಡ್ಯೂಲ್ ಇದು ನಾನು
Now come to page 27.
yes ಒಂದು ಸಲ ಮೊದಲು ಪ್ಯಾರಾಗ್ರಾಫ್ ಒಂದು ಸಲ ಕಲ್ಪೋದು ಓದಕ್ಕೆ ಅವಕಾಶ ಇದೆ
ತಾವು ಎಷ್ಟೊತ್ತು ಬೇಕಾ ಓದಿ ಸರ್.
ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಂತ
If these people act like this,
yes, we have not acted. There is a judgment of the Supreme Court which say that whoever has put up constructions kindly demolish there is a direction issued by the Capital Development to the Honorable Supreme Court in respect of this layout that whoever has put up unauthorized structures prior to 2020, prior to 2018.
when did the said order pass?
This order of the Honorable Supreme Court.
When did the said order pass?
Supreme Court.
Ah.
Supreme Court order in 47/2021. 47/2021.
This is after. This is after the order passed by a single judge.
47/2021.
Yes, sir, that is after order passed by a single judge. 7 June 2021. Read there.
Demolish ಮಾಡಿದ ದಿವಸ ಯಾರು ಹೇಳಿದ್ರು ನಾವು demolish ಮಾಡಿದ ದಿವಸ ಯಾರು ಹೇಳಿದ್ರು
Yes, read the order. They are given numbers, survey numbers also.
The petition he has given. That petition copy is not given to the advocate. The petition is not given to the PDA.
Mr. Reddy garu, we are reading Supreme Court. Supreme Court say given numbers, survey number. Show the 80 survey number.
The copy is set in the paragraph 3.
Supreme Court order was Swami. Para 6 ಓದಿ ಎಲ್ಲ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಯ್ತು ಓದಿ ಓದಿ. ನಾವು ಯಾರ ಮೇಲೂ ಕೋಪ ಯಾಕೆ ಜಡ್ಜಿಗೆ ಯಾಕೆ ಕೋಪ ಬರ್ಬೇಕು? ಕೆಲಸ ಅಲ್ದ ನಾವ್ಯಾಕೆ ಕೋಪ ಮಾಡ್ಬೇಕು? ಡೂ ಜಾಬ್ ಓನ್ಲಿ. ಗಡ್ಡಿ ಮೇಲೆ ಕೋಪ ನಮ್ಗೇನು ಬರುತ್ತೆ? ಎಸ್ ನಾವ್ ಯಾರ ಮೇಲೂ ಕೋಪ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ. ಓದಿ ಓದಿ.
Companies that despite the above order, new constructions are coming up in the land proposed for acquisition to that layout. BVJ is directed to some further constructions in the city of immediate and the above direction shall be implemented strictly.
It is only stop other construction, not to demolish existing building. ಓದಿ 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 ಓದಿ. Yes, yes.
It is made clear that buildings constructed after 3/8/2018 cannot be recovered and are liable to be demolished.
All.
ಇದು ಡೈರೆಕ್ಷನ್ ನೋಡಿ ಇಲ್ಲಿ ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಜೊತೆ
ಬೇಡ ಹಂಗೆ ಓದಿ.
ಸ್ಯಾಟಲೈಟ್ ಒಂದು ಬಂದೆ ಸ್ಯಾಟಲೈಟ್ ಇಮೇಜ್ ಅಂತ ಇದು ಡೈರೆಕ್ಟ್ ಮಾಡಿ ಇದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅನೆಕ್ಷ R4 ನಲ್ಲಿ ಸ್ಯಾಟಲೈಟ್ ಇಮೇಜ್ ಕೊಟ್ಟಿ ಯಾವತ್ತು ಬಿಲ್ಡಿಂಗ್ ಮಾರ್ಚ್ 2021 ಅಂತ ಫೋಟೋ ನಲ್ಲಿ ಇದೆ. ಅದಕ್ಕೆ ಮೊದಲು 2000 ನವೆಂಬರ್ 2020 ನಲ್ಲಿ ಕಟ್ಟಿರೋದ್ರಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಇಲ್ಲ, ಅನದರ್ ಸ್ಟ್ರಕ್ಚರ್ ಇಲ್ಲ. ಏಪ್ರಿಲ್ 2018 ನಲ್ಲಿ ಕಟ್ಟಿರೋದ್ರಲ್ಲಿ ಇಲ್ಲ. ಇದು ಕಟ್ಟಿರೋದು ಮಾರ್ಚ್ 2021 ನಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್. ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಅಷ್ಟೊತ್ತಿಗೆ ಬಂದಿತ್ತು. ನಾವೆಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ ಯಾರು ಪಾಸ್ ಮಾಡಿರೋ ಸಿಂಗಲ್ it is only when we went to the spot for demolition of the building pursuant to the order passed by the Honorable Supreme Court, then this order was shown. He did not give the survey number, he did not give the site number, he did not give anything. What can we do? It is put up after the judgment of the Supreme Court.
ಮುಂದೆ ಓದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಓದಿ.
ಇದು committee ನಾವು ಓದ್ತಾ ಇರೋದು. Paragraph 6. In our order dated 5/5/2021, we have requested the approval granted to the private developer with the purpose of the acquisition of the formation of the The committee of examination of the records submitted to the BVJ, all the checklist and its instruction report, has submitted report
reported 9/7/2021, certifying that the following waivers have been followed after permission of appropriate permission from the BVJ. The layout is survey number so and so. This layout is not in the survey number at all. This layout is not in the survey number at all. You are not even given the survey number, there is no site number, nothing at all is given in the order. He produces only the order. That is why they are saying in paragraph 5, he gave him time. You please demonstrate that which is your site, which is your thing. What the matter is disposed of by the court in terms of the earlier orders. Should he not have the courtesy to at least give a copy of the requisition to the government council or the director to be served? Should he not go and give a copy of the order to the Bangalore Development Authority? He doesn't do that. Copy of the order, the town gesture matters, disposal matter. In terms of similar terms,
ಇಲ್ಲ ನಾವು ಮಾಡೋದೇ ಇಲ್ಲ ಇವಾಗ.
he ಮಾಡೋದಿಲ್ಲ.
ಯಾವಾಗಲೂ ಮಾಡ್ತಾ ಇರಲಿಲ್ಲ ನಾನು. ನಂಗೆ ಗೊತ್ತಿತ್ತು ಹಿಂಗೆಲ್ಲ ಆಗುತ್ತೆ ಅಂತ. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡು ಅವ್ರ ಕೈ ಮೆಮೊ ಹಾಕ್ಸ್ಬಿಟ್ಟೆ ಮಾಡ್ತಾ ಇದ್ದೆ.
ಈಗ ನಾನು ಈ ಕೇಸಲ್ಲಿ ಅಪೇರ್ ಆಗಿ ನನ್ನ ಹೆಸರು ತಂದಿದ್ದೆ. ನಾವು ಯಾವ ಕೇಸಲ್ಲೂ ಅದಕ್ಕೆ 4 ಕೇಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಒಂದು ಫಸ್ಟ್ ಅಲ್ಲಿ. It is a fact that I have.
No, Reddy. Is it your case? Is it your case?
Yes.
Even now,
Yes.
you approach learned single judge.
Yes.
See, you have passed the order without hearing us.
Yes.
And there is nothing in the order.
Yes.
And subsequently Supreme Court passed the order directing BVJ demolish all the buildings existing after 3/8/18. I will file any application. You allowed that order with penalty. Even now you don't challenge that order. You don't file application for modification, for recall.
ಅದರಲ್ಲಿ ಏನು ಅನಾನುಕೂಲ ಇಲ್ಲ.
Demolish ಆಗೋಗಿದೆಯಲ್ಲ.
ಡಿಸ್ಅಡ್ವಾಂಟೇಜ್ ಇಲ್ಲ. ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆಗ್ತಿಲ್ಲ. ಸಿಂಗಲ್ ಜಡ್ಜ್ ಹೇಳಿರೋದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆದ್ಮೇಲೆ ತಪ್ಪಿಲ್ಲ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆದ್ಮೇಲೆ ಏನೇನ್ ಮಾಡಬೇಕು ಅದನ್ನ ಡೆಮಾಲಿಷ್ ಮಾಡಿದ್ವಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರೇ ಹೇಳಿದ್ರೆ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಹತ್ರ ನಾವೇ ಹೋಗ್ಬೇಕು. ಈ ಆರ್ಡರ್ ಆಫ್ ದಿ ಲರ್ನೆಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಇಸ್ ನಾಟ್ ಅಗೇನ್ಸ್ಟ್ ಮೀ. All the lorned single judge only says state maintains status quo as on that day. That order that Supreme Court itself says if any building is constructed.
Yes, Mr. Your building is situated where? 8 of what? This is a Dr. Shivram Karanth layout. Their Supreme Court says on 14/7/2020 demolish all the constructed buildings after 3/8/2018. When did you construct? Where is the material? Where is the permission for construction from the concerned authority? Mister, we are asking contempt. We want that submission, we'll record that, we'll dismiss every cause.
This is how the buildings are.
Everybody want to play with the court. Now time has come, we start impose cost on the councils. Irresponsible statement made before the court. Have you served copy other side? When the learned judge directed, served copy other side immediately? Intimated?
At least BDA.
One nimsha. Mister, you have got the order? You are the council? Is it not a negligence on the part of the council? ಯಾರಿದ್ರು ಅವರು ನೀವೇ ಇರ್ಬೇಕು ಅಂತ ಇಲ್ವಲ್ಲ, ದಟ್ ಈಸ್ ಯಾರು ಹೇಳ್ತಾರಲ್ಲ ಅವರು. ಮಿಸ್ಟರ್ ಕೌನ್ಸಿಲ್, ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಮೆಟೀರಿಯಲ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಆನ್ 7th June 2021. Government, the video director, advocate director take notice. Where you have served copy next day or before demolition to the other side, repetition copy on the order. If ultimately found, Mr. Prakash will dismiss every cost. ನಿಮ್ ತಪ್ಪು ಅಲ್ಲ, ಒಳ್ಳೆ ಕಥೆ ಆಯ್ತಲ್ಲ. ಇಲ್ಲಿಗೆಲ್ಲ ಕಟ್ಬಿಟ್ರೆ 15 ಲಕ್ಷ ಯಾವ ಕಟ್ ಕೇಳಿದೆ ನಿಮ್ಮನ್ನ? ಬರೀ ಅಲ್ಪ ಸರ್, ಆ ಹುಡುಗರು ಮಾತಾಡ್ತಾರೆ, ನೀವು ಮಾತಾಡಕ್ ಬರೋದಿಲ್ಲ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್, ಯು ಹ್ಯಾವ್ ಯುವರ್ ಓನ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್. ಆ ಹುಡುಗರು ಏನ್ ಬೇಕಾ ಮಾತಾಡ್ಬೋದು. The complaint filed the present contempt petition against the accused persons for willful disobedience of the order dated 7/6/2021 made in writ petition 9450/2021, wherein the learned single judge, while disposing of writ petition, directed the BDA. It is directed that till the BDA stroke Justice Civil Service Committee submit a report to the apex court in terms of its order dated 3/12/2020 and 5/5/2021, and until further orders passed by the apex court, pursuant thereto, all the parties are directed to maintain status quo in respect of these, in respect of the subject scheduled properties. ಅಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟೀಸ್ ಅಂತ ಇದೆ. ನಿಮ್ಮ ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರ್ರಿ, ನಿಮ್ಮವ್ರು ನೋಡ್ಬೇಕಾದ್ದು ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಏನು ಸ್ವಲ್ಪ ಕೊಡಪ್ಪ ಅಂತ ಹೇಳೋದು. All right. It is the grievance of the complainant that though the order was passed on 7/6/2021 and the construction of the building constructed in the scheduled property as stated in the more described in the petition has been demolished on 26/7/2021 by the BDA. On the date of demolition, though the copy of the petition, copy of the order was Lansing was served, the same was ignored and proceeded to demolish. Sri Prakash Learned Counsel for the complaint invited the attention of the court, paragraph 5 of the objection filed by the BDA, which reads as under BDA objection, paragraph 5. Thereby he submits a clear case of contempt. Sri Nanjan Reddy, Learned Senior Counsel for the complainant, reiterating the arguments made in the objections, contended that the very order passed by the learned single judge without notice to the BDA or respondents to stop. In fact, he pointed out at para 2 that the learned counsel mentioned, the learned single judge mentioned as under. Extract ಮಾಡಿದನ್ನ. Sri Nanjan Reddy submits, Nanjan Reddy Senior Counsel of this court submits that either Prabhulingan Awadgi, Learned Advocate General, appearing for state, or Nanjan Reddy, Learned Senior of appearing BDA, never appeared before this court. Other, in this case, full stop, the learned judge, while passing the orders in WP, ಸ್ವಲ್ಪ ನೀವು ಸುಮ್ಮನೆ ಇದ್ರೆ ನಾವು ಬರ್ಕೋತೀವಿ, ನಿಮ್ದಲ್ಲ ಅದು. ನೀವು ಸುಮ್ಮನೆ ಇದ್ರೆ ಬೆಟರ್, ನೀವು ನಮ್ಗೆ ಹೇಳ್ಕೊಡ್ಬೇಡಿ. ಅವರೊಂದು ಹೇಳಿದ್ದಾರೆ ಇಲ್ಲಿ, KSHJ ಪಾರ್ಟಿ ಅವರು ಇಬ್ರು ಆರ್ಗ್ಯೂ ಮಾಡೋದು. Specifically, stated that the learned judge, while deciding WP 8358/2020 on 20th January 2021, disposed of the writ petitions. Accordingly, several matters disposed of. Same is specifically stated in paragraph 3 and 4 of the statement of objection is as under. Stop. He would further contend that when the copy of the order was shown, in the absence of any particular distinct property or any portion of the order, the upsells of the BDA was sought the details from the complainant was unable to explain. Therefore, in the absence of any particulars, left with no option while carrying out the demolition work of all the unauthorized structures in the entire area. The unauthorized structures of the complaint were also demolished by the engineers of BDA. To stop. Sri Nanjan Reddy, Learned Counsel for the complaint, further submits, accused further submits that demolition of Dr. Shivram Karanth layout, where the property in dispute in present company is also situated, was demolished in terms of the order passed by the Hon'ble Supreme Court dated 14/7/2021 in miscellaneous application 1616/2019 dated 14/7/2020 by the Hon'ble Supreme Court, that is subsequent to the order passed learned single judge, that is on 7/6/2021, that subsequent order learned single judge 7/6 Supreme Court order 14/7/2021, wherein it was clearly stated in paragraph 3 as under. Thereby, Nanjun Reddy Learned Senior Counsel submits that the construction made in site number 68, assessment number 80, measuring 50/30, total 1000. Site number 26 and 27, assessment number 80, measuring 50/60, totally 3000 square feet, along with the RCC building formed out of land bearing survey number 80, situated at the Somsettal village, Yeshwantur Hon'ble, Bengaluru North Taluk, was constructed after 3/8/2018, the cut-up date fixed by the Hon'ble Supreme Court. The said submission placed on record. At this stage, Sri Prakash, learned counsel for the complaint, submits the construction was made before 3/8/2018 after obtaining necessary permission from the authorities concerned. The said submission placed on record. In the above, the complainant is directed to produce the permission letters or the sanction to construct the building before 3/8/2018. Call the matter next week. You have to clarify that is submission. And Mr. Senior Counsel, you are offering every day for BDA. If such things happen, why you should not got to notice of learned judge? ಈ ತರ ಅರಾಟಿಕ್ ಆರ್ಡರ್ ಮಾಡಬೇಡ್ರಿ, ತೊಂದರೆ ಆಗುತ್ತೆ ನಿಮ್ಗೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ವಾ? ನೀವ್ ಹೇಳ್ಬೇಕು, ಅವ್ರ ಕೇಳ್ತಾರೆ, ಕಿಸ್ನಿ ಯಾಕೆ ತೋರಿಸ್ತೀರಾ? ಇವರ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್, ಯು ಹ್ಯಾವ್ ಎ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಆಫ್ ದ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಲ್ಸೋ. ಹೋಗಿ ಅವ್ರು ಹೇಳ್ಬೇಕು, ಈ ತರ ಆಗ್ತಾ ಇದೆ, ಈ ತರ ತೊಂದರೆ ಆಗುತ್ತೆ ಸ್ವಾಮಿ, ಇದು ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳ್ಬೇಕು. ದಟ್ ಶುಡ್ ಬಿ ಗಟ್ಸ್ ಆಫ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಸರ್. ನಾವು ತಪ್ಪಾದ ಬಂದು ಹೇಳ್ಬೇಕು, ನಮಗೆ ನೀವು ತಿದ್ಕೊಂತೀವಿ ನಾವು. Because of the mistake by the council, because mistake of the by the learned judge, mistake by the council, by the BDA, this happening. Landing everything before the contempt court. Can we decide all the things in contempt? ಸುಮ್ಮನೆ ಒಂದು ಫ್ಲಾಟ್ ತಗೊಂಡೋಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ಹೊಡೆದಾಕಿದ್ವಿ ಅಂದ್ರೆ ಮುಗಿದೋಗಿತ್ತು. ನಿಮ್ಮವ್ರು ಹಂಗೆ ಇದ್ದಾರೆ, ನಿಮ್ಮ BDA ಸರಿ ಮಾಡಕ್ ಆಗಲ್ಲ. ನೀವು ನಂಜನ್ ರೆಡ್ಡಿ ಬಂದ್ರು ಆಗಲ್ಲ, ಯಾವ ರೆಡ್ಡಿ ಬಂದ್ರು ಆಗಲ್ಲ ಸರಿ ಮಾಡಕ್ಕದು. ದೇ ಪೀಪಲ್ ದೇ ಹ್ಯಾವ್ ದೇರ್ ಓನ್ ಮೆಥಡ್. ಬಾರಿ ಕಷ್ಟ ಸರ್. ವೇಸ್ಟಿಂಗ್ ಪಬ್ಲಿಕ್ ಟೈಮ್ ರೆಡ್ಡಿ, ಅನ್ನೆಸೆಸರಿ ವೇಸ್ಟಿಂಗ್ ಪಬ್ಲಿಕ್ ಲಿಟಿಗೇಷನ್. ಎಷ್ಟಿದೆ ಕೇಸುಗಳು? 15 ಇದೀವಿ ಇನ್ನ ನಾವು. ಅದೇ ಸ್ವಾಮಿ, ಅಲ್ಲಿಗೂ ಜವಾಬ್ದಾರಿ ಇಲ್ಲ, ಇಲ್ಲಿಗೂ ಜವಾಬ್ದಾರಿ ಇಲ್ಲ. ಎವ್ರಿಬಡಿ ಜಸ್ಟ್ ಥ್ರೋ ಕಂಟೆಂಪ್ಟೇಷನ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ನಾವೆಲ್ಲ ಕೇಳ್ಕೊಂಡಾಗ ನಮ್ಮದು ಬರಿಬೇಡಿ ಸ್ವಾಮಿ, ನಮ್ಮದು ಬರಿಬೇಡಿ. ನಾವು ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಮಾತಾಡಿದ್ರೆ ರವಿ ಅಂಡ್ ನಂಜುರೆಡ್ಡಿ ಸೇಸ್ ಯಾಕೆ ಅಪ್ಪ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ ಅಂತ. ಹೆಲ್ತ್ ಕಂಡೀಷನ್ ಅಲ್ಲಿ 24 ಗಂಟೆ ಗನ್ ಇಟ್ಕೊಂಡಿರ್ತಾನೆ ಸೈನಿಕ, ಅವನಿಗಿಂತ ನಾವು ಬೆಟರ್. ಅವನ್ ಪ್ರಾಣ ಕಣ್ಣ ಇಟ್ಕೊಂಡು ಸಾಯ್ತಾ ಇರ್ತಾನೆ. ನೋವಾಗತ್ತೆ. Immediately you should have served. The counsel for the petitioner should have served. ಎಕ್ಸ್ಪ್ರೆಸ್ ಮಾಡದೇ ಇದ್ರೆ, ರೆಡ್ ಗಾರು ಎಕ್ಸ್ಪ್ರೆಸ್ ಮಾಡದೇ ಇದ್ರೆ ನಿಜಾಂಶ ನಿಮ್ಗೆ ಗೊತ್ತಾಗೋದೇ ಇಲ್ಲ. ಅದೆಲ್ಲ ಹಂಗೆ ಸಪ್ರೆಸ್ ಆಗೋಗುತ್ತೆ. ಅಟ್ಲೀಸ್ಟ್ ನಮ್ಮಂತವ್ರು ಹೇಳಿದ್ರೆ ಒಂದ್ 4 ಜನ ತಟ್ಕೊಳ್ತೇವೆ ಅಂತ ನಮ್ಗೆ ಆಸೆ. ಇಷ್ಟು ಜನ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದ್ದೀರಿ, ಅಲ್ವಾ 200-300 ಜನ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದ್ದೀರಿ, ಒಂದು ಅಟ್ಲೀಸ್ಟ್ 20 ಜನಕ್ಕೆ ತಟ್ಟುತ್ತೇನೋ ಅಂತ ಆಸೆ. ಏನಾಗೋದಿಲ್ಲ, ನಥಿಂಗ್ ವಿಲ್ ಹ್ಯಾಪನ್ ಟು ಮೀ. ಆ ಕೋಪ ಆಚೆ ಹೋಗ್ಬಿಟ್ಟು ಏನೂ ಆಗೋದಿಲ್ಲ. ಅದು ಆಚೆ ಹೋಗ್ಬಿಟ್ಟು ಏನಾಗಲ್ಲ, ಒಳಗಡೆ ಇಟ್ಕೊಂಡು ನೋವ್ತಾ ಇರ್ತದೆ, ನಿದ್ದೆ ಬರ ರಾತ್ರಿಗೆ, ಇಷ್ಟೆಲ್ಲ ಅನ್ಯಾಯ ಆಗ್ತಾ ಇದೆಯಲ್ಲ ಅಂತ. We are not doing anything, just we are doing our job, we are doing our job, nothing for people. Yes sir. Yes Jagdish. Yes sir.
The government has withdrawn the order. The that without a submission are made that harassing the complainant. Thereafter, the contribution is made. Stating that the chambers have been locked.
ಯಾವುದೋ ಬೇರೆ ಚೇಂಬರ್ ಕೊಟ್ಟಿದ್ವಿ ಅಂತ, ಅದು ವಿಘ್ನ ಸರಿ ಇಲ್ಲ, ಚೇಂಬರ್ ಬೇರೆ ಚೇಂಬರ್ ಕೊಡಿ ಅಂತ ಕೊಡಿ. ಅಲ್ಲಿ ನಿಂತರು ಯಾರು? Where is your appropriate same chamber by handed over? So taken that. You file affidavit. I have not taken the key of that thing forcibly.
The question of taking the keys does not arise at all, because while I go to my chamber, there is one.
Bama. Sri Kiran Kumar, learned government advocate, on instruction submits that the chamber which was used by the complainant was taken by her forcibly after the orders passed by the learned single judge on 5th July 2021. To stop. To the attempt, file affidavit, shown photograph you will not, is disputing, and shown some photographs. The same is disputed by learned counsel, the Prashant, and submits when I have not taken possession of the room, not taken possession of the room which was used by Dr. Sujata Siddhappa. Question of filing affidavit would not arise. Submission placed on record. Enough the above, government advocate directed to file the affidavit of response officer with documents. ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ತಾಳಲ್ಲ ರೂಮಲ್ಲಿ, ನಾಳೆ ಆಮೇಲೆ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ವೆರಿ ಕಾಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಫೋಟೋಗ್ರಾಫ್ ಮೇಲೆ ವಿಚಾರ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಎಸ್ ರಘುಪತಿ, ನಿಮ್ಮ ಪರ್ಸನಲ್ ಈಗೋಸ್ ಎಲ್ಲ ಬಂದು ಸೆಟ್ಲ್ ಮಾಡಕ್ ಪ್ರಯತ್ನ ಮಾಡ್ತೀರಿ ಇಲ್ಲಿ. ವಿ ಡೋಂಟ್ ನೋ. ಐ ಆಮ್ ಡಾಕ್ಟರ್ ಸುಜಾತ ಅಂತ ಹೆಸರಿದೆ. ಎಸ್, PhD ಡಾಕ್ಟರ್. ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ರಾಜೇಂದ್ರ? ಮುಗ್ದೋಗಿದ್ರೆ ಮುಗ್ದೋಗಿತ್ತು. To take instruction to dispose of the matter. ಏನ್ ರೆಸ್ಟೋರೇಷನ್? ಅವ್ರ ಹೆಸರು ಎಂಟ್ರಿ ಆಗಿದ್ಯಾ? ಹಾ, Rajendra, show from the records prior to the order dated 26/2/15 by the deputy commissioner your name shown, then we'll get back your name. Otherwise, ಹೊಸದಾಗಿ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ನೀವು ಹೊಸದಾಗಿ ಹೋಗಿ ಮಾಡ್ಕೊಳ್ಳಿ ಏನ್ ಬೇಕು ಅಲ್ಲಿ ನೋಡಿ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ. ಸಿಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೆಲಸ ಅಲ್ಲದೆ ಎಲ್ರಿ ಅವ್ರಿಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಡಿ. ಎಲ್ಲಿದೆ ಅದು? ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ
2015 affidavit was already pending. Today's affidavit, current affidavit showing the name of Armane Kaur, restoring the name of Armane Kaur.
ಎಲ್ರಿ ಅದು ಪೇಜ್ 4 annex R1.
Next, page 5. Whatever the first thing is asked to elect. Armane Kaur, next page number 5.
That is column 9.
Column 9. ಈ ಅರಮನೆ ಕಾಲದ ರಿಸ್ಟೋರ್ ಮಾಡಲಿಕ್ಕೆ
ಇಲ್ಲೂ ಇದೆಯಲ್ಲ ಕಾಲಮ್ 12 ನರಮನೆ ಕಾವಲು. Rama. The complaint filed the present contempt petition for willful disobedience of the order passed with learned single judge, wherein the learned single judge directed to revenue authorities, municipal authorities, consider making appropriate entries in the names of the petitioners upon representative being made in accordance with law as per applicable procedure in the light of the finding. The Tahsildar Mysore Taluk, the affidavit and specifically stated in para 2 and 3 as under. What is the survey number 4? You summarize down. Paragraph 4, 5, Sri Rajendra 6 times to verify whether the name of the once our charges payment you can't appear. Yes, yes. In the court, the charges authority we request Vikram Paul ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಆಮೇಲೆ ನೀವು ಕಾಗದ ಮಾಡಿ ನಾವು ಚಾರ್ಜಸ್ ಏನು ವಾಪಸ್ ತಗೋಕ್ಕಾಗಲ್ಲ. If you can't take a position, you should not have made the undertaking before the court. Should not give an instruction to the other judge.
I don't know whether it is that one is whether it comes to get.
You don't know. We are ready. Exam chip agli matte ಮಾಡಿ ಬರ್ದವರು. He did not guilty. I have defense and stated that I have no power to demolish construction made in property thereby constructed in spite of order of the. So the Ravi, other senior counsel appear for the accused 6th time. Call next week. Next week, Mark. Yes. Varsha. The joint request of learned of both the parties for this matter 2 weeks for settlement effort. Call it 3 weeks. Manjula. Yes, Manjula. What is the order? Yeah. What is the order, Tayi? Correct. What is the contempt? ಎಷ್ಟೊಂದು ಫಿಲ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರಮ್ಮ ಎಲ್ಲಿದೆ ತೋರಿಸ್ತಾಯಿ ಅದು ನೋಟಿಸ್ ರಿಟರ್ನಬಲ್ ಫಾರ್ ವಿಚ್ ದಟ್ ಇಸ್ ನಾಟ್ ಅ ಕಂಟೆಂಟ್ ಅವ್ರು ಏನ್ ಬೇಕೋ ಮಾಡ್ಕೋಬಹುದು ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ಟಾರ್ಟೆಡ್ ಪ್ರಾಜೆಕ್ಟ್ಸ್ ಫ್ರೀ ಟು ಫಿಲ್ ಅಪ್ ದಿ ಪೋಸ್ಟ್ ರೂಲ್ಸ್ ಫ್ರೇಮ್ ದೇರ್ ಅಂಡರ್ ಇನ್ನ ಕಾನ್ಸೆಪ್ಟ್ ಲಾ ಅಷ್ಟೇ ನೀವು ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಮಾಡಿಲ್ವ ಎಷ್ಟು ಸಲ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿಲ್ಲ ಎಲ್ಲಿ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದಾರ್ರಿ ಯಾವಾಗಾದ್ರು ಮಾಡ್ಕೋಬಹುದು ಅಂತ ಹೇಳಿದಾರ ಅವ್ರು ಮಾಡ್ತಾರೆ ಯಾವಾಗಾದ್ರು ದಿಸ್ ಇಸ್ ಎಂಟ್ರಿ ಮಾಡರ್ ಎಸ್ ಮಿಸ್ಟರ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹಾ ಏನ್ ಪೋಸ್ಟಿಂಗ್ ಆಡ್ಸಪ್ಪ ಏನಪ್ಪ ದೇವರೇ ಕಾಪಾಡ್ಬೇಕು ಓದಪ್ಪ ಜನ ನೋಡ ಹಾ read para 4
relation to data entries. Second to the interim order being granted by this. All the additional charge was created in favor of the
How we arrange for it? Appointed as all working as designated as interim order granted as for the
Yes, ma. They have done the job. Nimman ಮಾಡ್ಬೇಕು ಅಂತ ಮಾಡಿಲ್ಲ. They have done the job. Para 4 ಓದಿ. Para 4 ಓದಿ. Vedic appointment order. Rules correct. Page appointment order. The appointment made by us as per rules also. Where is that order? Appointment order. What happened? Or what? Madam, this is interim order, no final order passed. Now the final appointments are made. If you have any grievance against final order, you challenge that order. No contempt, dismiss. When did the final order pass?
2nd March
2022. Whether petitioner succeeded? ಇಬ್ಬರು ಗೊತ್ತಿಲ್ಲ ಏನಮ್ಮ ಗೆದ್ದಿದ್ಯಾ ತಾಯಿಯಲ್ಲಿ ಅಯ್ಯೋ ರಾಮ ಏನ್ ಡಿಸ್ಪೋಸ್ ಅಂದ್ರೆ ಏನು ಅಯ್ಯೋ
ಏನಾಗಿದೆ ಆರ್ಡರು
ಮಾಡ್ತಾರೆ ಬಿಡಿ ಮಾಡ್ದೇನು ಆಮೇಲೆ ಬನ್ನಿ ಅದರ ಮೇಲೆ ಇದು ಕಂಟೆಂಪ್ಟ್. We are not concerned. We are concerned entire world. You are concerned entire world. You are concerned only the order. Bama. The complaint filed present contempt petition. Take action is the appeal persons with the power of subsection 11 contempt for fact of willful disobedience of the order dated 18/8/2021 made in WP 13 the willful disobedience of the interim order dated 18/8/2021. Made in number 30/1 wherein the learned single judge will issue notice to respondents stayed the operation of the order dated 24/1/2017. The grievance of petitioner that inspired order not complied the order. The respondents filed objections. The affidavit dated 2/2/2022. They specifically stated paragraph 4 as under. And the affidavit dated 9/2/2022, paragraph 4 stated as under. Paragraph 4 and 5 stated as under. And subsequently, the coordinate bench of this court by the order dated 28th October 2022 disposed of the very writ petition 13/5/2020. Lakhs around in the order. Para 15 and 16 reads as under. The order passed by the single judge, the court and bench on merits as they have challenged this order. Where?
Whether you have challenged it or this order passed in writ petition, final order challenge ಮಾಡಿದ್ದೀರಾ?
The order passed by court bench has reached finality. Any of the complaint are not made of any intent as alleged. Accordingly, the pass the following contempt of the drop. Operative person ಕೊಡಿ ನೋಡಲ್ಲ ಮಂಜುಳಾ ಏನೋ ಹೇಳ್ಬಿಡ್ತೀಯಮ್ಮ ಲ್ಯಾಕ್ಸ್ ಮೆರಿಟ್ಸ್ ಅಂತ ಹೊರದಾಕ್ತಾರೆ ಸುಮ್ಮನೆ ಲಾಸ್ಟ್ ಆಪರೇಟಿವ್ ಪರ್ಸನ್ ಓದಿ ನಿಮ್ ಫೇವರ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಬ್ಸರ್ವೇಷನ್ಸ್ ಅಷ್ಟೇ ಎಸ್ ಚಂದನ್ ಅಮ್ಮ ಒಂದ್ ಪಾರ್ಟ್ ವೈ ಕೊಡ್ರಿ last time also finally 1 week time ಆಗಿದೆ ನೋಡಲ್ಲ ನೀವು ಲಿಂಗರಾಜು ಮತ್ತೆ ವೆರಿಫೈ ಏನ್ ಮತ್ತು ಏನಕ್ಕೆ ಇಟ್ಕೋಬೇಕ್ರಿ ಇಲ್ಲಿ ಅನ್ನೆಸೆಸರಿ ರೆಕಾರ್ಡ್ ಸಬ್ಮಿಷನ್ ಆಗೋದು ವೆರಿಫೈ ಕೊಡ್ರಿ single judge order is subject for writ appeal or not? Then where the widow? Writ appeal number kodama 1403 of 21. One nimsha any entry matter dated 29/12/21. Cross appeal 1 of yes come the record of submission they will say no sir sorry the present contempt petition is filed by the complainant to take action against the accused under the provisions of section 11(12) Contempt Court Act for willful disobedience of the order passed by the single judge dated 21/10/2020 made in WP 31/7/28/2013 wherein the learned single judge directed that a sympathetic consideration is required to be made by the MUDA in considering their case for allotment of any other side subject to petitioner complying with the scheduled payment without default. Mr. Madam Poonam Patil, learned counsel for the accused submits against the order passed learned single judge. The accused filed writ appeal 14/3/2021 and the division coordinate bench of this court by the order dated 29/12/2021 stayed the operation of the order passed learned single judge. Mr. She also submits that the present complaint also filed cross appeal 1/2022 that is pending. The said submission is placed on record. You disputing that? The same is not disputed by learned counsel for the complainant. In of the above, we pass the following order. Contempt proceedings are hereby dropped. Needless to observe, it is always subject to result of the writ appeal 14/03/2021 and cross appeal 1/2022 pending between the parties. Yes. Appeal number. General counsel for the appellant file. The complaint file memo. Permitted withdraw the contempt petition with liberty to approach the appropriate authority. The memo dated 3/11/2022 is placed on record. In of the above memo, the complaint is dismissed as wrong. Yes. Srikanth, General Counsel for the complaint submits that in your subsequent development, the present contempt would not serve for consideration. Submission placed on record. In of the above, for the contempt of the court.